Good morning, good morning, good morning. Or should I say, hear ye, hear ye, hear ye. It's Wednesday. It is, what day is it? It's May 28th. It's day 22 of the Karen Read Retrial. And I think this is the Commonwealth's last witness because we are with Accident Reconstructionist and Biomechanical Engineer, Dr. Welcher. I think it's also witness number 38. We have lots that have happened yesterday. Dr. Welcher gave a number of opinions, including the opinion that Karen... hi, Dr. B.
Hello.
Good morning.
Good morning.
We're streaming.
I'm dropping things off.
Thanks. I totally forgot what I was saying because I got so distracted. What was I saying? Where was I? I was doing the intro and I lost my train of thought. So what were we talking about? Dr. Welcher gave opinions. That's what we were talking about. Dr. Welcher gave his opinion that Karen Read's car was not damaged by hitting John O'Keefe's car. He gave the opinion that the injuries on John O'Keefe's arm matched geometrically to Karen Read's vehicle. And he gave the opinion that was then stricken that Karen Read struck John O'Keefe with her vehicle. We will get back into that today because that was at the end and that was stricken. And I was very put off by a number of things by this expert, including that he said that is what happened. John O'Keefe was struck by Karen Read's Lexus. That is what happened. That is an expert testifying to an ultimate fact for the jury. He can have an opinion that John O'Keefe was struck by a car and that the damage to the car and the damage to John O'Keefe are consistent. I don't know how he'll get there, but if he can explain it, but he can't say, yeah, Karen Read hit John O'Keefe with the car. That's what happened. And that's what he was trying to do yesterday. And this is an expert who has testified numerous times. He should know better. I don't even know. I've never seen an expert attempt to testify to the ultimate fact because they're so conscientious of what their role is and the fact that they're there to inform the jury and help the jury make decisions, not to act as the jury themselves. So the only way to solve it, I think, is to go to court because it's time to go to court. And for all of you asking, could that cause a mistrial? The defense did not ask for a mistrial. The defense does not want a mistrial. All that happens if you get a mistrial is that this jury gets dismissed and you start all over again in a few months. That is 100% not what the defense wants. And it's not enough that's going to cause a dismissal. So we'll finish up direct. We'll get to cross. And that's going to be where we, I think, spend the entirety of today. Because I think we're just about done with the Commonwealth's case. Are they going to rest today? Let's see. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Will we get hear ye's this morning? That's my big question. I guess we'll see. I hope that we do. We're unmuted. The only fan said hello and good morning. Let me know where you're coming in from, what you're drinking. I've got coffee. I don't have as many books as the judge does in my hands, but I got coffee.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the
well, we're getting right into what the court's ruling is from yesterday. I don't even have my notebook open, but we'll do it in a minute. What can Dr. Welcher testify to? And it's not that he can't say that he thinks that that happened. It's that he can't say that is what happened. So let's back this up. I guess we're getting the ruling bright and early. No good morning, no hey, hello, how are you? Let's right into it. All right, good. Let's get into it. Like,
all right.
Let's do it.
Good morning, everybody. All right, so
good morning, law nerds. Good morning. Good morning.
Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Read's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application.
Oh, that's not true. There was objection. And there was a whole motion filed about it.
However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility.
Really?
Rather, it is that Dr. Welcher, the expert, is drawn.
Wait, really? Wait, really? Wait, really?
Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather,
how? I need to just, if you're a Massachusetts lawyer, my email's public. Can you just send me where that is? Because how is testifying to the ultimate issue not a bar to admissibility? I just don't. I'm gonna need to fact check that at some point. Today is not going to be the day, but I'm gonna need to fact check that at some point, because what? Then again, last trial we were told that biomedical engineers couldn't testify to injuries because they weren't medical doctors, and this trial it seems to be perfectly fine. So magic.
it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method.
Okay.
So that's the ruling.
I agree.
So the jurors are lining up.
I agree that he can testify to the consistency. I agree with that. That was going to happen. I am not surprised she said he can't testify to the ultimate issue. I agree with all of the things that the judge ruled are founded in law. What I'm concerned about is what the judge is saying isn't coming in. I'm concerned that in Massachusetts, testifying to the ultimate issue isn't a bar to admissibility. That is wild. But I thought that the judge was going to allow in the opinions. Any judge would allow in those opinions. It was the way he said it last time that was the issue. And that's exactly what the defense argued yesterday. He can say the damage to the vehicle is consistent. He needs to have basis for that. He can say that the damage to John O'Keefe is consistent, and he needs to have basis for that. Those things I thought would 100% come in. So am I surprised by the rulings? No, I'm just surprised really by that, I don't know, dicta statement that in Massachusetts, that's not a bar to admissibility, because what? All right.
We should have them momentarily.
Let's get into it.
Thank you
So-
for my coffee.
Okay.
I have no idea what he just said.
Thank you for my coffee.
Okay.
Still no idea.
Is Dr. Welcher right around? Why don't we bring him in if he's here before
I don't know why our
jurors?
closed captioning is not working, chat. No idea. Just no idea. As they get everybody into the courtroom to get started, the jurors, they said we're lining up. There we go.
Okay. Are you in agreement with this, Mr.?
He did not provide coffee to the defense. He provided a copy to the defense of the redactions.
Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I would go with
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order.
I mean, okay.
Do you know the number? You don't have to find it if you don't.
Why didn't we do this earlier?
Oh, is this was it 1:30? Was it 1:31 yesterday too?
It was.
So at Sidebar, I said we could go back to that. And Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132.
There was
that
lots
was my
of jumping
understanding
around.
at Sidebar.
it is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at
Why
it
didn't
again.
they
That's
do
not my
this?
understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Why didn't y'all do this
Yeah,
earlier?
No, I'm okay with that.
Yeah.
That one, yes, your Honor's recollection is correct.
Yeah,
I'm okay with the heading removed.
And we were going to start on that, but you thought because I struck it based on the objection, but then at Sidebar I said we could go back to that. That's your
She
understanding
struck it
too.
so fast.
And I'm sure that Dr. Welch.
Like, it didn't even have time to sit down. She struck it
I
so
think
quickly.
he did, but because I think he took off from 124 to 1.
I did.
Okay.
I would have liked your prediction to come true.
I think he said I'd like
Are
the
they
court
out there, Paul?
prediction
Okay,
to
thank
come
you.
true. A lot of you have asked, what does bar to admissibility means? It means that an expert in the right circumstance can testify to the ultimate issue. It does not bar or stop it from being admissible. A bar to admissibility means this thing means it is not admissible. And she is saying an opinion that goes to an ultimate fact does not stop something from being admissible, which is wild to me. Because that is, I think, invading the purview of the jury. All right. They are rising for the jury. So we are going to zoom. She's going to ask those first four.
Questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday?
Agree with.
Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
All right. We're back to direct. I imagine they're going to get back to
Good morning.
those
When we
questions.
left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first is,
So getting back into the opinion from
I'd
yesterday.
ask you to turn to your PowerPoint, slide 110.
Okay. At least we're off to a
You want me to
smooth
display it?
Please.
start.
I'm going to ask you a question about a series of your slides regarding this
No, I was
effort.
pulling up
This
a
is
second stream.
110.
That was
Could
me.
you also
I was pulling up a
follow
backup feed.
through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to
Sure, I want to see the videos.
acquaint you for the question.
111,
12,
112, 113, 114, 115.
how many times did you engage in testing where your arm and forearm touched the rear
I mean, I wanna
right
know that too.
of the Exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
What?
If you
Why
could
would
turn
he even
to
ask that?
slide 130, please.
Such a weird question.
Could you go back one, please? Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance
Just call me
of
Hen
this
said,
slide,
sorry,
please?
he crashed into the car with his own arm. Yes, yes, he did. Yes, he did.
Oh, could you take that down, Dr. Welcher?
Sure. Thank you, Mr. Bryant.
We're going to move forward. Down, Dr. Welcher.
I have never seen an expert have this many like difficulties, especially with the amount of issues that we have had. They have had numerous hearings on this. They have done very thorough motions in limine, and still it's an issue.
Thank you, Mr. Bryant.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this slide down.
Sorry,
you could take the PowerPoint down, please.
that was in a different spot on this line. Hold on a second.
Also, if there are things that the court struck or asked to be redacted, take them out of your PowerPoint overnight.
That's right.
Thank you. Sir, I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made
I guess we're
regarding
getting into consistent.
testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that
Not
you
just, I can
reviewed
hear this comment
a
in the
number
chat.
of pieces of
Yes.
information
Why isn't
and offered that you
anybody
relied on
ready?
some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information
Well, at
did
least
you
I had
rely
breakfast.
on? for
What are
the
you guys
opinions
eating?
I'm going to ask you.
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the
is the
photographs
background
of Miss Reed's
of his
vehicle,
opinion.
To a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Okay, thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I need the same type of shoes, my exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the tech stream data as well.
That information that you consider,
I think there was probably more than that, but okay.
in addition to the tech stream data you consider, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in
Here's
whether
his opinion.
the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it.
What? Is it your opinion that the damage to the Lexus is consistent with striking John O'Keefe? Well, there's two theories on that, sir. Sir, the jury instruction for beyond a reasonable doubt literally says if there are two reasonable explanations for an event, you jury, you must pick the one that points, and in some jurisdictions it says to innocence, and in some jurisdictions it says to not guilty. So your opinion is could be that there's multiple things. Do you have an opinion about whether the damage to the Lexus is consistent with striking John O'Keefe. This is wild. Brennan asked the question really clearly this time. We're going to back it up and listen to it again. I'm floored that the expert is like, actually, there's a lot more to say. I can't just say, yes, I have an opinion about that. This is the opinion based on those things I just said. No.
Certainty.
All right. I'm going to let Brennan ask his whole question.
Do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether,
Likely?
based on the data and based on the physical damage
What a
in your
mess.
testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you
I've never
consider,
seen,
or do you have an opinion?
I've never seen an attorney have to ask an expert like 3 different ways if that's their opinion. Why? Because these things are discussed well in advance. And there's a report. His opinion is there's 2 different theories of what happened. And it's likely that if it's more than 8 miles per hour, that the taillight would break. Likely? How do you know that?
To a reasonable degree of engineering
It's
certainty,
too early.
whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022.
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And
That
is
was at least a
specifically
clearer
pertained to
opinion.
January 29, 2022, around 12:30 a.m.?
He can't testify to that.
I'm going to allow that.
Why?
Yes, it does.
You shouldn't.
To finish, I'd like to ask you a few more questions. You've written some papers on side swipe collisions.
I want to hear more
clipping.
about
Can
this.
you describe for the jury and explain what a side swipe collision is, or a clipping? And
I do want to hear
how
more about
that may
this.
or may not differ from a direct hit on a pedestrian impact.
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you're going to have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's the glancing hit, doesn't completely transfer to the object being struck.
Okay, that makes sense.
For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer.
I mean, you're
So
also
when
going
you
to have a
have
whole bunch of,
glancing contact,
driving
you can have much higher speeds
hundreds of
without
bits.
a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a...
If a car drove by someone at a excess of speed and hit a human with their side view mirror, even if it didn't completely transfer to the human, there would still be damage.
As a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated.
Vaulting?
Because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash.
Okay.
If the impact had occurred in the center of the vehicle,
It didn't.
and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other...
Ty in the chat asked, didn't the state say 24 miles per hour, or was that last trial? It came in yesterday, but it also came in yesterday that this expert's opinion was that he cannot say when John O'Keefe was hit or at what speed John O'Keefe was hit or where in the tech stream data John O'Keefe was hit. So they said how fast the car backed up, but they did not say when in that sequence of backing on the tech stream data John O'Keefe was hit, or if it was after the tech stream data ended. So they have not contended that John O'Keefe was hit at that speed. They have left open multiple possibilities, which becomes a big problem for the prosecution because they are supposed to be closing the doors on possibilities and arguing to the jury, this one thing is what happened. All the rest of these possibilities are ridiculous. Sure, lots of things are possible, but in this case, only this thing is possible. It's like in the Murdaugh case. In the Murdaugh case, you have a very strong argument that the thing that happened to the victims is that they were shot. Sure, there's lots of possibilities in the world for how people can die, but in that case, those victims were shot. And then you have to argue about whom did that. So you have to close the doors. Here, he has not been closing the doors to possibilities, and neither did the neurologist who said, yeah, we see these injuries all the time when people fall backwards, slip on the snow, have a heart attack. And he said, yeah, there's two possibilities. It could have gotten broken this way. It could have gotten broken this way. So the Commonwealth's job is to close all the doors to possibility. And when you have, well, it could be this, it could be this, it could be that, you're not closing those doors. And that's what the problem with these experts have been. Well, there's lots of them, but primarily is they aren't closing the doors to doubt. The coroner said, well, I can't tell you if this or that is more reasonable. Therefore, it's undetermined. And he has not, for me, closed the door to this is the only way this could have happened. The taillight could have been broken this way. The taillight could have been broken that way. John O'Keefe could have been clipped by the car. We don't have enough information. Okay, but if he could have been clipped by the car, could those injuries happen if he's not clipped by the car? That becomes the critical inquiry for me. Okay, he's saying this could have happened if he's clipped by the car. Well, could this have happened if he's not clipped by the car? And I think based on the neurologist, yes. You don't have a case here where they are looking at the victim and the victim's injuries and saying, the only way this could have happened is from a vehicle. That's not what is happening in this case. And that's a real hard position, I think, for the Commonwealth to overcome reasonable doubt.
Difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
He's
So
trying
for
to answer
pedestrian,
it.
correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen.
Rotation. We're back to rotation.
Post-impact motion of the person. So cadavers, crash
I will
dummies
be muting myself off
don't
and on.
have any muscle reaction.
Well, the
So
lawnmowers
the
are
motion of a
lawnmowering.
crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions,
Oh,
by
Chad, he was
front
saying
or
you
back
put your right
bumper,
foot in, you put
as
your right
opposed
foot out.
to side swipe.
That's
or
where we're at.
clipping somebody. Is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred
right.
to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases?
We're not just talking about broken bones, though, Brennan. Bruising? I mean, I get that people bruise differently, but if your legs are impacted at some point, even if it's slow speed,
is that you've studied or been involved with, where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
we're not talking about, okay. He's talking
I'd
about
ask you to
broken
turn
bones,
to
Emily. He's just
Slide
doing
139,
that.
please.
Sir, friendly advice. It feels like you and I are in the same place, my guy. And for me and for you, it is probably time for both of us to consider the real possibilities of bifocals. Because I get that you are trying to see what is down in front of you and that is a challenge. But if you are testifying and you have to look at the thing, just make it easier for yourself. Or it's time to lift up the glasses while you're looking. I know it is not a fun place to be, where you need the distance to see the far things, but then you can't see the close things. I get it. But also,
Oh, sorry.
it's probably time.
I fixed those other two slides.
Okay.
On the stand in real time.
Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where
The name v. name indicates that this is a civil vehicle collision case.
we had, this is a image from the police report. Oh, Let me see if I can.
Thrown 38 feet?
So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Right, because it's sharp.
Next slide, please.
Oh,
And what does this represent?
good Lord.
So this is the decedent.
Okay. I'm going to just adjust my screen. No, I'm just going to let them testify until they switch slides. It is a photo of the decedent with a breakdown of the case.
In the case, the person that was hit, he was killed at the scene.
I don't know why they put a
what you
picture of another
see,
decedent on the screen.
on the left-hand
chat.
image.
Apologies.
Oops.
All right. They switched. Oh, no, they switched back. They almost got me. They switched slides and then they switched back.
Left-hand image.
I don't know why they have done that, but they have.
Yes, he had a massive
They have now zoomed all the way into that image. So
laceration
with
to his
some very large
right
lacerations.
forearm, but
Are we going to switch sides?
it didn't break his arm. There was
That's a really big laceration, though.
no broken bones in his arm.
Okay.
On the right-hand side of this image, you
Can we
see the
zoom
autopsy
out?
report.
All right.
What you'll know
Hold on. I'm going to make myself a bit larger as we talk about this slide until it's done so that we have what they're talking about now. And I will continue to just do that. So we are doing that. All right. Let's continue on.
notice is
Why?
he had
I don't know.
red marks on his leg,
The camera finally went,
buttocks,
we're done.
but he had no leg fractures.
Okay.
And again, this individual was hit at between 25 to 35 miles an hour.
Can you
Thrown.
expand that? I'm sorry.
Yes, yes, Your
Do
Honor.
you want that expanded like other times?
They're expanding the writing from the autopsy report
Yeah, no, my pleasure, Your Honor. Thank you.
to
So
show to show a collision at 25 to 35 miles per hour and to show the injury without broken bones.
at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration.
Rib fractures, liver laceration. What other injuries? Keep going.
You look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand.
Nope.
Extremity
What are we
with
doing?
vascular injury.
I'm not
So-
sure what they're showing.
No fractures.
Okay.
If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremity,
They're showing the list of injuries from the autopsy report, which include numerous hematomas and hemorrhages, fractures to the right posterior ribs. These are fractures clearly not caused by life-saving measures because they wouldn't have done life-saving measures at the scene on this. Bilateral hemothorax, pneumothorax to the lungs, liver laceration, right upper extremity wounds, and then the abrasions. Right. I'm not a doctor. I'm just a girl that did a lot of vehicle collision cases, including homicides.
they're no
Right. Uh-huh. Injuries to the body.
noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
I feel like Brennan is missing the point. fractures aren't the point. The fractures aren't the point. The injury to the right knee, the left anterior leg, the lower back, the right lower back, the left side of the buttocks, the posterior right leg, the right ankle, all of the impact with the road type of injuries are also not surprising. Same with the fractured ribs and the hemothorax and the pneumothorax. Like, right. It's not about, oh my God, it's not about the pasta. It's not about the broken bones specifically.
Okay.
The poor jury this morning, it's like, good morning, here's somebody else's photos from the scene.
Dr. Welcher, regarding your
collision.
analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move to evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
Time for cross.
That's by agreement, Mr. Wilson.
Chris, do you mind letting the app know that we are moving on to cross? So he said that it is consistent. I'm just trying to write down the
Both
opinion.
The flash drive and the notebook.
Presentation, it's consistent with the same set. I have no objection.
So let's put them both together now.
Sir,
and
don't
decide
help.
later.
Thank
Okay.
you.
Don't interject. Don't interject. Don't interject.
The slides are incorrect on the flash drive.
Okay, so we'll switch that.
That was
Thank you. What exhibit number is it?
All right.
Thank you.
So it's 206A and B.
I suspect this will be a fairly lengthy cross-examination.
All right, Mr. Alessi, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
Yeah, I think we will have a fairly lengthy cross at this point. The expert gave numerous opinions. I would have to go through all of my notes to find all of them, but gave numerous opinions. The most critical opinions for the Commonwealth were the opinion that John O'Keefe's injuries are consistent with being struck by a Lexus identical to Karen Reed's, that the damage to Karen Reed's vehicle is consistent with striking a pedestrian at more than 8 miles per hour, that, which is a number we had never heard before in testimony. So if you're going to ask me, Emily, how did he determine that? I don't fucking know. He didn't tell us at all. Like at all. He gave the opinion that not having lower extremity brakes is consistent with a side swipe vehicle collision. Okay. And that you would expect to see redness. And they are
Morning, Dr. Welcher.
keying in
Good
on the
morning. We
redness to the
haven't been
victims.
formally introduced. Your whole
Name.
name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Not
Nice to meet
Lessie.
you.
Alessi. Not Alessi. I've not seen an expert do that either. Normally, Mr. Alessi says, this is the first time meeting. Dude, don't try to power struggle with Alessi. Look, I know that the chat wants to just cuddle Mr. Alessi. I get it. But don't try to intellectually joust with Mr. Alessi. You are going to lose. All of you asking, can you do that? He can do whatever he wants. It's just how it looks to the jury. It just goes to how it looks to the jury. That's it.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Alessi.
Dr. Welcher, The area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is accident reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court.
Y'all, what should Alessi's answer have been if we're not in a court setting? If we're not in a court setting, is the proper response, it's Brittany bitch, or is the proper response Bond, James Bond? Or is it Thesaurus Daddy? Or is it Robert Alessi, Bob if you're nasty? Like, what is the proper response if we're not in court? Right? I am Batman. Chuck Norris, Robert Alessi, shadows fear me. Grammarly could never. It's just so weird.
When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically.
Thank you, chat, for humoring me on my side quest.
It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
Forensics is done because it is going to intersect with the law.
Exactly, yeah.
Okay, yes, certainly for the court of law, yes.
It ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Yes.
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree.
Alessi, you can already tell this is going to be nothing in the vicinity of straightforward. This is not going to be anything near straightforward when he's arguing over whether or not the truth is subjective or objective. We're not even going to get close. He's gotten fully into the vicinity of that's my truth. Like, okay. You're an engineer, sir.
Engineering certainty, is that correct?
Correct.
You've also, have you used the word sometimes to a reasonable degree of scientific certainty?
I might have a cup of coffee. So
I don't know.
In terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
I would
Critical
imagine
analysis?
so.
Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand The goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
That's what he said. I hate that analogy, but that's what he said.
Quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That
correct?
is 100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So, in terms of
I've never
you've
met an
agreed
engineer
that
quite like you, sir.
Apply the scientific method, so I want to
I
see
try.
if you're in agreement generally so that
Alessi. Do or do not. Alessi. Do. Channel the force, Alessi. Channel it. I try. I try. Can you imagine like a civil engineer being like, or a structural engineer being like, I try to do my best. I mean, sometimes the buildings fall down, sometimes they stay up. It's great, but I do my best. You know, nobody's perfect. You know, we moved to Decimal Point. That whole bridge just whoop. But you know, it's fine. I do my best. We try. You know, there's room for error in engineering. Said literally no engineer ever, like ever.
the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Everything's going to be couched.
Is it
then?
correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted?
He seems to have quite a lot of peer-reviewed articles, though.
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process.
He misunderstood the question. The question was, don't you use the same methodology that has been peer reviewed in other circumstances? So in other circumstances, you take the methodology that has been tested and then you apply it to this case. There's like, I don't know, a method. There's like a methodology for how to do that. And you should know that because you were part of the peer review.
The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
so
sorry, sure,
to
to
get
interrupt
peer,
you.
It's not what he
I need
asked.
to.
Go ahead and answer.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis.
Sir, are you being intentionally obtuse? Because I don't think that you misunderstand the question. The question is pretty clear. That peer-reviewed methodology can be applied in different circumstances. That's like my understanding of the foundation of science. Like we have a methodology and then you can like replicate it. That seems to be like a critical component of all of this. And I avoided most science classes like the plague, but it's just you do the thing, you create a methodology, and then you repeat the methodology, and then you come out with results that are reliable because you can repeat the methodology. And whether the results are, you know, A, B, or C, you know the methodology is right, so you know the results are reliable because it's been, you know, replicated.
Analysis here in this case.
Oh boy.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
So yes?
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, this is, biases
That's a funny answer. I'm not mad
don't
at
you
that.
agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias.
I appreciate
Let's
him
talk
making
about
the
confirmation
distinction, but
Now, confirmation
Look.
bias is...
I appreciate he understands where his lane is now. I just wish we had a little stay in our lane yesterday when he's like, this is what happened. I wish we had a little more stay in our lane then. Okay, but I don't think that's what Alessi means by cognitive bias. But again, when you get to experts and scientific experts, you are going to get explanations for the answers. But Alessi's questions have been consistent this trial in where he starts with scientific experts. And this is the first one that has really fought him on. So the point is to come to an objective result. This is the first one who has fought him. Everybody else has been like, yes, we would like to science.
actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally,
confirmation bias is. And an example of confirmation bias is,
I'm going to start using that. I'm stealing that line. I'm stealing that line. When people just dumb at me directly, I'm going to be like, that is a statement. Period. Just period. That is a statement. And done. I'm 100% stealing it.
Not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it.
Kelly, I think we've got you.
So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay,
generally what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned
directed at what
part
happened?
of the data gathering?
Correct, but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
I'm asking myself questions along the way today.
That
how did we get here?
For you, at
what are we doing?
Some point,
why are we fighting on the basic fundamentals of the scientific process?
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you...
Oh, boy. Sir, if you keep fighting for Alessi, he's going to bust out SAT words that you've never even heard of with so many syllables that you didn't even know existed. Alessi is going to create words out of the ether, and they will be in the dictionary before the end of trial. If you're going to fight with him, he is going to intellect at you. Oh, boy.
Then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front. How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning. Can you
We'll get some
help me
words
with
of the
that
day.
logic?
Sure, I guess I misunderstood. Like I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree
Look for evidence.
then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence,
Alessi's
you
gonna start
window
saying,
down
"Don't stop me now,"
the
in a
number of
second.
questions.
Maybe I can just this last question and make it clear for you, sir.
So you start with the
You would agree,
hypothesis.
not analysis, which you added, as I heard it to the last part, just hypotheses. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
If you don't have a hypothesis, where do you go from there? And I mean, at least for the US based audience, didn't we start doing this in like 6th or 7th grade with like, you start with a hypothesis? Like, all of you are going to start yelling that the mitochondria is the powerhouse of the cells again, but isn't that where we started with like basic fundamental understanding of science? Didn't we start there? It was 5th grade. Some of you are like, Emily, 5th grade. It was 5th grade. Thank you. Yeah, my memory's not great. Lindsay said Canada too. I think it was 4th grade science. Right. A lot of you were saying 4th grade, 5th grade. Perfect. Thank you. What is happening?
And
I mean, we didn't learn to do taxes, but we do have some things ingrained in our minds.
These hypotheses.
Emily, now is not the time to rant. I know.
Would you agree that those hypotheses should be tested?
Yes.
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
He's speaking generally.
Isn't it the case that when you have multiple hypotheses, The one that
Are you writing
most,
it down?
out of all of them, it's a relative thing. The one that
Are you word
most
mapping the question?
consistently produces the same injury emerges as the mechanism of injury. Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate.
Okay,
but there's exceptions.
Have any of you ever taken a test where you have read so much into the question that you've talked yourself out of the correct answer because you've overthought the entire thing? We're watching that happen in real time. If you try to outsmart the lawyer, you are going to wind up in a pickle like this. These are very simple questions that aren't a trick. There's no trick. Should science be objective? Yes, there's no trick. The trick is going to come, and it's not even a trick, we can see where it's going, but did you do that here? This is groundwork, but you're trying to give yourself wiggle room in every single answer and over reading into them. It's incredibly frustrating to watch.
Fair enough, but it's a general principle
Sure.
with some exceptions. That's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clearer.
He was just trying to get to the fundamentals of science.
Switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yeah.
And there are troopers within the Massachusetts
boy.
State Police.
Sir, did you read their reports? Did you read their reports?
Collision Analysis and Reconstruction section, whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Did you read their
Are you
reports?
familiar with a Massachusetts State Trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know...
I'm familiar with his reports.
Right.
I don't know the man.
Okay, familiar with Trooper Paul through his reports in this case,
So he did
correct?
read them.
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a reconstructionist in this case on January 29th of 2022?
Do you think the defense takes bets on how many
as
times
evidenced by
they can
that
say
report
Proctor
or
and
those
across?
reports of Trooper Paul? Do you know that?
Because that
Well,
was
you
one.
put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
Proctor counter.
You were
this cross.
retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
I think you would
Don't
only know the
know.
report.
That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you
That's fair.
know when, the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
Yeah.
You know
have him
that
pull it
the
up.
date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's
month and year is what
within
matters.
a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years.
He told you not to look. Stop
from
looking.
the date of the incident in
He's not going to stop
if I
looking.
did the math right.
Stop
correct?
looking.
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
Oh, boy.
On November 5th of 2024,
Turn off your screen. You just keep looking at it. It's like trying to talk to a distracted preteen.
your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office
I was wondering
to
about that.
conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Right. How much did you pay for the Lexus? But how much did you pay for the Lexus?
Do you recall whether Aperture has...
David,
Well,
that's
do
true.
you believe Aperture
Distracted
is
preteens would probably
working
answer
for
more
free
directly.
in this matter?
Oh, no.
Oh, I don't believe he was paid $44,000. I think they have probably been paid more or will be paid more because I think they'll probably be paid for the Lexus. $44,000 is low. I think it's going to be more. I mean, look at his. Did you expect to be paid to work for free? Oh, no. Playing the money game, though, it goes both ways because Aperture is going to get paid too. And Arca is going to get paid too. So. But I'm not surprised. All these firms do the billing separately. All of them do. But they're going to be paid way more than that.
Whether Aperture has... Well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would-
engineering company. We bill for our time. So
Right.
So you know that Aperture is getting paid for its work in this case, correct?
we are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
Whoop, there it is.
Would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024? Wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
What?
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this
what?
case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Yeah.
go right to the billing.
He thinks he's caught Alessi in a critical error. Is it an error? Yes, it was an error. He's right. Alessi's incorrect on how much time, but now the expert is like, haha. But sir, if you're going to want to play a game of gotcha, it's going to come back round.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection.
He doesn't
I'm not
know.
part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual
Yeah, that's what he said.
relationship between Aperture and the Commonwealth?
No, that's
Oh,
not
no,
what he
no.
said.
I was sent a contract by the Commonwealth to sign.
He doesn't
so I'm
know
aware of the
if they've been
contractual
paid.
agreement, but the day-to-day or month-to-month invoicing
Yeah.
and billing, I'm not involved in that.
That doesn't surprise
Okay.
me.
So you're aware there's a contract between Aperture and the Commonwealth?
This exact
I
same
signed it.
conversation
And you
is going
signed
to
it.
happen with Arca. by
And
the
wasn't
way.
that contract obligating the Commonwealth to pay for the services of Aperture. Isn't that the purpose of the contract, in part?
In part, sure.
Yeah.
This is not a
it's
great
legal
line
obligation of the
for
Commonwealth.
Alessi.
Your firm does work, and the Commonwealth pays for it.
Alessi,
correct?
move on.
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Right, and it's
Also,
the government. They trust that they're
you
going to get paid.
testified
It's going
on
to take a while, but they trust
direct
they're going to get paid.
That there was a purchase of a Lexus Exemplar
That's what I want to know.
for your testing.
Correct.
Who pays for that Lexus Exemplar?
Yes, I want to know.
Aperture?
And is that then
Reimbursed?
cost passed on to the Commonwealth?
No.
Really?
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly.
Well, that seems relatively fair for all of it. So they're going to sell it. Hopefully not internally, but they're going to sell it and then they're going to bill the Commonwealth for the difference. That makes sense. And the Commonwealth will pay for it, but will pay for less of it. Okay. Again, that's fair. That makes perfect sense. They're not going to keep it and they're not going to charge the Commonwealth for the whole thing. All right. That's fair.
That was where I was going, sir. So,
But they're only paying the difference. So
That's better than
in
I thought.
theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the
That's fair, too.
obligation was. So
The
it's-
obligation is the difference.
exactly. So the obligation is the difference.
They would need to sell it at fair market value. Because it'd be really weird to me if this dude just bought it and started driving it. Would I put that past any of this? No. No, I wouldn't.
Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And
really?
Isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth
mention it all. Mention it all.
What?
And isn't it the case
What?
that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000, and is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that,
That's not a legal opinion. They put down a $44,000, it seems, retainer and authorized a contract for $325,000. So when I was yelling about whether or not Aperture was padding their bill or was overcharging or was overworking on things that didn't need to be charged, I was asking about the rate they were charging for Burgess based on Burgess's education or debunked education. I was curious about Burgess doing all of the work to re-download and fly to get stuff from Karen Reed's Lexus that had already been downloaded. I was interested in how much was going to be billed. Well, now we know. Up at least $325,000. So, Burgess did a lot of work that I don't think he needed to do. I don't think the jury gives a shit about any of it. I'm kind of stuck on it. The jury's not going to care. Why does it matter? Because they're going to charge a lot more than ARCA did. And it's really rare for the defense to get to ask government experts this, because most of the time when you have a trial, the government experts are law enforcement. And so if the accident reconstructionist comes from the police department or law enforcement, it's like, did you get paid for this? Yeah, I got paid the same thing I get paid every day. I am on salary. I just get a paycheck. It's rare to have government experts that are getting paid this much. Occasionally you will have a doctor come in who's an expert. They're getting paid for a day or whatever, but it is incredibly rare that in a criminal case, the defense gets to ask the prosecutor about spending this much money. A lot of agencies would not approve spending this much money. I think it's telling that they did. And for the jury, it's like, so somebody else already did this work, and now you're paying you to do this work. And the defense is going to loop that back around, I suspect, to argue they didn't like the answer from Trooper Paul. So they spent $325,000 plus to go get the answer they wanted. That's where the argument's going to go. And it's more than ARCA. So when the government starts going, you're getting paid, so you're getting paid, so you're swayed in the direction of the person that's paying you, this kind of locks out that argument because it comes back around, right? Okay, well, if you're going to argue that ARCA's being paid for an opinion and they're just going to give the opinion of the person that's paying them, isn't this the same? That's a lot of money. That's a lot of money.
Are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no. I'm not aware of anything we've been paid.
Oh, boy.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained.
He didn't say that.
Did I have your answer correct about how long you've been on it?
No.
I guess
said less than a year.
Closer to 8 months?
All right, so 8 months. So for 8 months of work, about $400,000.
Did he say like 6 months?
Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
I mean, look, I'm not going to justify the amount that they're billing or charging. I just gave you my thoughts on it. But it's not one person doing the work. There are probably a lot of people working on this. That I don't doubt.
Don't know.
But
I definitely did sign the contract.
I don't know if it's all work that needs to be done.
Is to who you
CEG
signed the
3 minutes ago.
contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract.
Sure.
May I put you on it?
Yes.
So they retained one company that is divided work over 3 offices, and the government approved the money.
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
Can you direct me so it'll take less time? It's a lot of money. Like a lot of money. Like a lot of money. It's a lot of money.
When he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
It really does open the door for argument, doesn't it?
There you go.
Can I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh?
All
Or
right.
would you like me to start with
So-
refresh?
Go ahead and start with refresh. Go back to the podium, please. Thank you.
Thank you, Your Honor.
My God.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So
Is your
for my
signature on
office,
it?
yes.
So are you saying that
Is
therefore?
your signature on it?
And did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall?
What do you think
the
we're doing here?
amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the
very long
contract
day.
that's listed in the contract? You
No.
recall it? May I approach your honor?
Sir, do you just not want to get on a flight to Massachusetts
Dr.
or to
Welcher,
Long
I'm
Beach
now
today?
going to, you asked
Like-
me last time, I hope this is helpful.
You're just happy to stay in Mass another night because you're
going to
be here all day.
I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum
Did you sign it?
obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
But if you're signing contracts for your company, shouldn't you know, like, how much you're being paid? I feel like that's one of your, like, fiduciary obligations.
Right.
You know. Okay.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct.
With
that you
regards
didn't
to
have any dog
fuckery.
in the
We
hunt.
got
You
started with
recall
regards to
that
fuckery.
statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
Great. Alessi
You
could have moved on earlier. That number is
an
shocking enough that it's
updated
going to be memorable.
PowerPoint presentation.
Ooh.
The one that you went over on your direct
I want to hear about
examination.
this. The jury might not care about this line of questioning, but I want to hear about it.
You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial
That
started
doesn't
approximately
surprise me.
April 22nd of 2024.
84 years ago.
Did you create your updated presentation before or after April 22nd of 2024?
I don't
5.
know.
25. Alessi, this one's 25.
Do you
Last
know
trial started April
when-
24.
Dr. Welcher, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
I appreciate that the court interceded there and said, I would appreciate you not looking at things. Alessi might not be able to see what he's looking at. I don't think I've seen the court jump in to shut it down like that this trial, but I appreciate that the judge is like, I'm asking you not to look at it, which I appreciate.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue.
Alessi might not be able to see what he's looking at because of how low down it is on
Are
the
you
podium.
able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to
Honor,
do.
may he do that?
Yes, I'm going to see counsel at Sidebar while you pull that up.
she just told him to stop looking at it. He keeps flipping through whatever he's got, laptop or iPad or whatever. He keeps scrolling through it while Alessi's asking the question, just so we can talk about the proper procedure. If we saw this when I was screaming about it with Dr. Curry versus Dr. Hughes, if you need to refresh your recollection, you need to say, I would need to look at my report to refresh my recollection. I can't answer that without referring back to my whatever the thing is document. And then the defense can say, no, that's okay, we're moving on. Or they can say, yes, please find that. But what you can't do is just be like, well, I would need to look it up. And then you're sitting there just scrolling to look it up. You need permission to review. The scientific witnesses in this case said, I would need to review my report to get all like the evidence numbers in and stuff. And the court said, yes, you may read that in from your report. There is process for it. And he keeps jumping over it and just scrolling through. And sir, you should be aware, I well am, you're wearing glasses. We can see the reflection of your screen in your glasses. From here, we can see that you're looking at the thing the entire time because it's reflecting in your face. This is, in fact, a memory test. And you have to ask for permission each time. And he did it last time. I'm going to zoom past this sidebar. In the chat, Jessica H. asked, why permission? Because you cannot just read something in without saying, may I refer to my insert the thing? And then everybody knows what you're referring to because your testimony is the testimony, not your report. The reports are not testimony. And you need a clear record of it. So if the witness is reading something, everyone needs to know what the witness is reading off of. And there are times when you're not allowed to refresh it.
What I ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you.
He needs to be told to not read his shit.
I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer.
And the court has
Alessi's
shut it down. You need to put down. You need to put down the laptop cover. You can't just read it in. I said this with Don Hughes too. As an expert, you are being paid well to do your job. And I am much more critical of experts than I am of civilian witnesses. Because A, you do this all the time, and B, you are getting paid to be here and do this. If you don't want to go testify in court, don't be an expert that testifies in court. Pick a different job. That's fine. It's just so improper.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create
So improper.
the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that,
The redacted.
that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So
do you
every day.
Keep
So you
updating
change
it.
the presentation every day.
This is not what experts are supposed to be doing. And we've gotten now to it's every day, bro. Will this matter to the jury? Maybe not. Because the jury is not sitting here from lawyer perspective going, there are expert disclosure periods. And once the expert disclosure period is done, it stops. It's not like it's every day, bro. It's not like giving a presentation at a conference where you can update it until 3 minutes before you walk on stage. Emily, that sounds incredibly specific. It's different.
Since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks?
Saving it every day. Don't change it every day.
Your presentation.
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question.
May 13th? I think May 13th was the answer.
Your first version, as I understand it, of the slide presentation was January 30th, 2025?
Yes.
Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Okay, that was clear.
Assuming the trial started
That was Burgess, right?
April 22nd of 2025, you changed your PowerPoint presentation
While you were in trial.
during this trial, correct?
Yes, correct.
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 And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't.
No,
While you're on the stand.
I'm not sure how much granularity you want to that answer.
Great. So
Thank you to everyone in the chat.
created on January.
To everyone in the chat that is refraining from just screaming and calling this witness names, I appreciate you. I appreciate you. Y'all are doing great.
30th, 2025, you made your
13th.
pardon me?
Oh, the original one. Sorry,
Yes.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your
Y'all are
first
doing
amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
Y'all just
That is
mobile
correct.
gaming.
I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times
700
did
years
you
ago.
change your
Lies.
presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change.
Changed
Half
it.
of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brannon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay,
Okay.
let's break that down.
No, Alessi, that is a clear answer to a clear question. I think it's time for Alessi to move on. That's a clear answer to a clear question. He modified it, which means the redactions based on the judge's ruling. That's fine. That's fine. Just if Alessi keeps going on this, the jury's going to be like, he answered it. Stop it. He modified it May 13th. That's the big modification they're talking about. The other modifications were redactions from the court and Brennan, saying you have to take that slide out. Okay, it's time to move on. Okay, fine.
You said
move on.
half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the
He's just
paths
throwing
to
that
every
in.
single slide
I changed
about
it
where
because
the
of
evidence
you.
came from, because they were saying I didn't provide everything,
I
and
changed
I
it
had
because of
provided
you.
everything.
I changed it because of you.
So
That was the second half.
got it. I want to go to the first half, sir.
Sure.
You
I'm
get
gonna
what you
try to
asked for,
shortcut
defense.
this, and if I'm not clear, you just let me know. I want to talk about the first half.
I put on hand
You
lotion.
called
now
it, I
can't
didn't
open
hear
my-
it. It was like, did you say
Lip gloss.
path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. what you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements allege that Ms. Reed made. Is that correct?
I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
Warning.
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
That's a reasonable explanation.
You were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
Really?
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welcher, I have to ask you not to refer to that.
I'm trying to be helpful.
Close your computer.
Let me close it. Sorry. I was trying to answer his question.
The man can't stop opening his computer. I'm glad the court called him on it. The court, he's like, no, I'm trying to find the info. You're testifying on the stand. You don't get to just keep scrolling through your computer. Somebody take it off the stand. Just take it. Your Honor, yeet his computer. And Alessi is getting off the rails on this point. I think the witness answered it well and explained it well. And oftentimes the jury likes the experts, probably more than I do. So if we keep hammering on, but you changed it, he's like, right, because the defense wanted me to change it, so I took it out. And if Alessi keeps banging on about it, lawyer Emily can be annoyed that he changed it because I know the import to all the teams. The jury doesn't know. The jury doesn't know about the disclosure deadlines. The jury doesn't know about any of it. He's like, I changed it and then I took it out because y'all had a problem. Done. It's too granular. I'm really glad that the court is just hammering him on looking at his computer, though. The court's like locked in on it.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat. Thank you.
Thank you, Your Honor. So assume the clip.
It's embarrassing as an expert to be told to stop.
Said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly.
It's the Dateline, not the Dateline, the Discovery ID. When did that air? That aired in April.
About this clip.
Right?
I need to look, but I remember it being about mid-April.
It aired right around then.
If I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So
it
they
aired March
then
17th.
indicated
Okay.
there was this suggestion of an alternative route.
Body in the Snow from Discovery ID aired part 1, March 17th. The prosecution didn't get that footage until it was turned over in April. So that's actually probably close in time.
So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route that they wanted you to look at?
So I took it to be, we have additional evidence.
Right, there's more
Please look at the
information.
additional evidence and add it to your analysis.
That's fair. New info can get included. He said that on direct.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting
That's
a
fair.
report dated May 8th of
He said that on
2025
direct.
in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit
for
that May
speculation.
8th report to the Commonwealth?
Yes, we had had a discussion before that he had found new information
Oh.
that changed the timing.
What?
Oh, he had found new information. What
Oh, you had a discussion about new information? I thought it was just based on the report.
is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
No,
I'm going
that.
to allow the question, but you have to ask it differently. Mr.
I will,
Wilson.
Your Honor. Thank you.
And the court overruled the objection from the prosecution to the question. He's
What
going to
is the
rephrase
basis for the statement you made that Mr. Burgess found new information?
Yeah, why? How do you know that?
I guess it was his
Public hearsay.
meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon
Yeah.
the representation of Mr. Burgess.
Yes.
You didn't have any independent document to determine whether, in fact, it was new.
Correct.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir,
Frankly, my darling, he does not give a damn.
has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report?
All of you, not all of you, a lot of you asked me earlier, can the defense get into things like disclosure deadlines and discovery rules? And 55 seconds ago, I would have said no. But I think now the defense, if they wanted to travel down that path, has grounds to say, so you don't care if it's new, you don't care if it's old, you don't care. But you've worked in civil cases, you've worked in criminal cases. Are you aware that there are deadlines for things? Do you care about the deadlines for things? You might not be able to get into specifically what those deadlines are, but you can get into, aren't you aware that there are procedural deadlines? Because he should be aware of those things, well aware of those things. And I think that answer allows for that question. We'll see if we get there.
In the middle of a trial, you said you
But,
testified
bro.
in state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of the trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then?
It was compound, Alessi.
Any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
Wouldn't an amended analysis be an amended report? Well,
You're
I guess
welcome.
not every.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay.
Oh!
All right, folks, why don't we take our morning recess again? Dr. Welcher.
Let's take our morning audacity break.
Love to use the restroom.
What did he say?
Love to use the restroom.
Again, Dr. Welcher, right behind.
Great.
The court said something to Mr. Welcher.
Morning recess again, Dr. Welcher, right behind.
Great. Love to use the restroom.
Oh, I'd love to use the restroom. Fair enough. Yeah, it took me a second to hear it. All right, we're going to zoom past the court break and the bathroom break. That's a long break this morning. We're going to get back into real time as we skip the morning break. Yeah, love to use the restroom. That's completely fair.
All right, whenever you're ready, Mr. Alessi.
Thank you, Your Honor. And if I could please address an administrative matter that I wish I didn't have to address.
An administrative matter that I wish I didn't have to address.
Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
Yes.
Closed. Yes.
Would he open?
So did you just turn it on?
No, but I will. I closed it.
It's preposterous.
Like want the computer all the way off or just everything?
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at Sidebar,
Sure.
please.
This should have been done before the jury came back. And Alessi is right. This has been an ongoing issue. This is why most experts will bring a binder or a printout of their presentation and not be operating it from their own devices. So, for those of you who are like, you're just hard on this expert, just go watch How I Felt About Dr. Hughes doing the same thing. My distaste for experts who
Take all that.
game
I'm sorry?
is consistent. I do not like it at all.
Lunch break, I'll ask you to remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during
Take
the
it
lunch
down
break,
now.
okay?
No, Your Honor, fuck it. Make him take it down now. Take it down now. Take away his toys. This man just keeps going back to the tech. Miss Little's got a whole new haircut vibe going. I dig it.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day?
Oh, I'm sure he's not aware of that.
No.
Okay, and now the jury's aware.
And you
They're probably not going to care.
began testifying the day after yesterday, correct, sir? Day after Memorial Day?
Yeah.
I testified yesterday.
Yes.
Yeah, the jury's not going to care. The defense cares. the jury's going to be like, okay, so you got an updated report. Fine.
Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up, and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, you know, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, he was told to redact it.
They asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications.
Betsy, I think this is a good question. Alessi's walked away from the mic. Betsy said, how is it fair if I don't agree with it? There are things that I find in this case that are legally fair, even when I don't agree with them. But again, lawyer brain is like, no, I can see how that is legally accurate, even though I disagree, which is something that is hard to do outside of court, to be like, no, that's fair. I don't like it, but that's fair. And it's hard. It is hard to be like, this is a fair question. This needs to move on. Whether I like the attorney, like the witness, or what have you, there are going to be times that are good. There are going to be times that are bad. There are going to be answers that are good and answers that are bad. There are going to be things that are fair, even if I disagree with them. And it is part of looking at the law as it goes. You know, you can applaud a good play for a team that you don't like. So it's fair. Just insert name of opposing team. Like, you know, USC or whatever. The Southern Cal, UCLA family. We'll move on. Let's get back to Alessi walking away from the mic.
This trial is going on relative to you amending your...
Like, were you told about what was going on during trial?
An amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Kathleen, that's totally fair.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events.
I'm glad he's moving on.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event.
We're well aware of that.
Not at the time of this event.
It does now?
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car,
Look at the easy answering.
this one you push the button.
Clean question.
That's a new
clean
key cycle,
answer.
right?
That will cause a key cycle.
So correct.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred,
Yes.
correct?
The EDR data, no.
So EDR
Oh,
data
the
gives
text
you
stream
no
data.
information about the number of seconds into the key cycle that a particular event occurred.
That comes from different
You're
data.
confusing EDR data and text stream.
I'm not, sir, I'm just
Are you not?
asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, have sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data
Is not the EDR
indicates
data.
the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In
That
order
was the
to
issue.
properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
The
Trigger.
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with
Okay,
a
they've
particular
moved on to
key
trip
cycle.
data,
Is
which
that a
we
fair
haven't talked
statement?
about much.
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence
It's a good line
in
of
the text
questioning.
stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle,
It's like buttoning
then
a
your
shirt wrong.
estimate of
You're
when the
just
text stream event occurred will
just-
also be wrong. Isn't that just a matter of logic, sir?
throws it off.
So, again,
like,
the text
no.
stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
So it would be the
If
infotainment
you
system that
associate the
could.
wrong trip
He's saying that's not possible.
with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
I don't think that's what he
You
said.
can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
That's fair. It's in the text stream data. I think Alessi's
Let me
confused
try it a different
on that
way.
point.
Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Well, so
Again, you need to take the totality of the data.
Really compound.
So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of tech stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the tech stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolf,
And I think
yes, I've
the
got
problem
correct
was Alessi was
Thank
trying
you,
to
Your Honor.
parse key cycle and trip data apart, and he said, no, key cycle and trip data are coded together, but if you can attribute those to the wrong event. So I think Alessi was trying to parse something that couldn't be parsed, and he was saying these two things can't be parsed apart. It's the third thing. I'm interested to see where we're going with this next.
So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key
Very
cycle
curious to see
1167?
Correct.
And in this screenshot, we can see 4 tech stream events that are...
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll.
Oh, gosh.
So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 tech stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 tech stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 tech stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right.
Right.
So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question? All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all tech stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Alessi.
Sir, as part of your work in your
What are you looking
review
at?
of the many documents that you referenced on your direct examination, did you review the tech stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
I don't know what he's looking at.
It did. It did not include 1166.
I didn't mention
Probably paper.
1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time? You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been, and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, that base, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir, that there were do you recall that there was a report of Trooper Paul?
Yes.
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No. I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But
Did you look at
did
it?
read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see a sidebar on this.
Oh boy. We are going to start getting into prior or previous theories and key cycles. And some of that may not be able to come in with this witness. So this is a tread carefully. This is a tread carefully area because some of the stuff from Trooper Paul's report will not come in. There's a little bit of a longer sidebar. We're going to zoom past it because we've got zoom room. So we're going to get into conversations about key cycles. What matters most is what he's expressing now, not what was expressed before. Kellen in the chat said he read and used Trooper Paul's report. He said he read it and reviewed it. He said he did his own analysis. He can be asked, did you see that, well, he may be able to be asked, did you see that Trooper Paul determined this and you determined something different?
Are you aware that over the course of the Commonwealth's
this is a tread carefully
investigation into this case,
and she's
that
allowing
the
it.
theorized time of the alleged contact of the SUV?
So there's 2 words, just strike theorized.
Thank you, Your Honor. Are you aware
She's
that
allowing
over the
some
course
narrow questions
of
on this,
the Commonwealth's investigation and your
Hold on, Mr. Alessi. Court reporter can't hear.
Thank you. I will.
I'm not surprised the court reporter can't hear.
I'll object again to the question that's coming.
And the Commonwealth is objecting and objecting and objecting, and the court is saying you can ask this in a narrowly parsed way, which I'm actually a little surprised about.
Do you
I don't
have
mind being surprised. I
knowledge
think it's proper,
whether
but I'm surprised.
There is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that.
You have to rephrase.
Understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
They're going to end up back at sidebar in a minute.
I'm not giving the instruction now.
Dr. Welcher, In terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
A poorly
I'm
phrased
going to see you
question.
again, folks. I'm sorry about this.
There is a very narrow road for these questions about whether or not, and this is where I think the defense is going, whether or not the timing has shifted, because he's trying to lay the foundation, I suspect, to get to, and then everybody matched things up after the point. But the court, instead of shutting this down, is allowing things in. It just is a very fine point to make and a fine line on it, because the Commonwealth has not presented that information this case. I wonder if Alessi's going to change the way he's getting there, like just take a different fork in the road and ask about reviewing Trooper Paul's report and coming to different conclusions, because I think that might be a different way to approach it, but they're going back to Sidebar about it, because again, it is something that has to be pretty finely parsed. So I'm not surprised that the court's being careful here. I'm not surprised by the amount of Commonwealth objecting. I'm more surprised that the judge didn't shut it down entirely, and I think that's appropriate. But it is a fine line, and jumping over that line can create problems. Miss Little's like, and here is all your stuff. The other thing is, this witness did say
Yeah, Your Honor?
Yes.
he could not specify a time. And I think being able to ask, well, you can go about it that way too. However, I am not going to downplay how difficult this is to do on the fly in court with a million things in your brain. The thing I have to worry about today is like finishing my breakfast, having lunch, streaming with y'all, and family stuff. I am not also trying to figure out the rest of a cross-examination. It's much easier for me in the moment than it is in court in the moment. But it is frustrating when you really do have to be on that kind of tightrope of questions to phrase questions exactly right. And that's where Alessi is. It is a difficult thing to do. So it, you know, again, easy for me to say sitting here with 50,000 law nerds that I get to run ideas by. He doesn't get to do that. The court is allowing it, which I think is also a win.
I'm going to move to, for the moment, we'll come back to the other topic a little bit
I think
later.
that's actually a solid plan to come back to it after lunch and take the lunch break and go point by point to come at it from a different direction. And I think that's fair.
As we discussed earlier,
because they're going to have time.
Got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is it is biomechanical engineer
or biomedical
something you consider
engineer.
yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right.
Griffin, we are
Now,
trying to do this on mobile.
In your report,
I've asked a lot.
and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need your?
I do.
I've never seen anyone so fucking glad to grab their report in their life. Like it is a fucking lifeboat. The swiftness with which he grasped for the papers.
And, Your Honor, I have no issue if he refers to the page of his report.
Give me my papers!
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did.
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And
But
you go
you
on
opined
to
about
add
the
on
arm.
page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assessed the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So, you know how to, do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get.
Or you can just use the force.
Is
and try to derive what's on your laptop without opening it.
Second law of motion. And in the second law is force equals mass times acceleration. Correct?
I'm glad Newton has come into the chat. I was waiting for that. We didn't get to that. We hadn't gotten to that yet.
One or more of those, but I'm focusing on when you're trying.
Sir, for the love. When you're on the stand, you can't just do shit. I think it's a TI something calculator. I don't think that's a phone. I think he's grabbing a calculator. Sir, you can't just do shit. Take his bags away from him. Take them away. He keeps just pulling out props. But that looks like a calculator to me. But I'm really glad we got to Newton's laws, because that section of the testimony with Trooper Paul last time was very interesting. And I don't think this engineer is going to be caught slipping on Newton's laws of gravity and physics and whatever. Me, yes. Briefly. And then we're getting back to this. We were, Travis and I were staying at a hotel in Michigan before we left. Loved the hotel. And because it has more of an academic theme, on blackboards kind of around the lobby, it had equations on it. And I was like, oh, math. And he's like, actually, Mom, that seems to be physics. And I was like, okay, but a type of math. He's like, what? And then we had to debate over physics equations vis-a-vis other types of equations. I'm like, look, man, I took the bare minimum required mathematics in high school. This is not for me. I liked statistics. It was more logical. Look. So then we got to fighting over physics. So now we're here with this man and his like AP Chem calculator, and I'm dying. So, but yes, we had a very fun conversation about it.
To determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right.
Don't be prepared. Your job is to sit there and answer questions and stop digging around in whatever's at your feet.
Force
I agree the physics uses
mass acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sort of you're pulling something out.
Calculator. I thought you were going to ask me numbers and do calculations.
All right. We need to do, if we're going to do that, we need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
here.
right.
So
Stop
I just want to get
it!
the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that.
Why don't you just ask him to explain it?
Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured
Right.
in the test.
And can you tell the jury what is meant by G's?
So
Not
G's
like
is
G's
a
up.
measure of acceleration.
Emily, stop it.
If you take, usually acceleration is measured in feet per second squared. If you divide it by 1 G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by
is
what we
G's
all
more
feel
proper
when we're
than G
standing here, which is
forces?
1 G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of the head? So if we apply Newton's second law,
It is one of the
keep F
best
force open as
wordplay
the
lyrics of all
unknown.
time. Real G's move in
We
silence like
take and
lasagna.
apply
It really
the
is.
mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the...
I was going to make a whole lot of real spicy comments. But yes, centers of gravity are different. So factually, yes, because centers of gravity are different. But I also have spicy comments about what?
The previous unknown
Nope,
F.
Emily,
in the
move on.
Newton's second
Chat can
law
fill it in
equation,
for
correct?
themselves.
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go
Emily,
on
you read
to
too many
note
books where people have
that
wings.
the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
No, Alessi, no. We've gone from G's winged characters in books back to the occiput boner. Just all the way back. We're all the way back to the occipital bone.
Right?
Correct.
So you then,
oh boy,
as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry. 40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds.
I live in a nerd house.
And then it says, and a drop distance as low as 40 inches.
I have a
Right. And is the number
skull that's my husband's.
634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct.
I also have some decorative
So
skulls.
if you
Some
can
skull
get a
candle
fracture
holders
of the
and
occipital bone
skull candles,
in an
glittery
average force of
skulls.
634 pounds.
No.
I'm sorry.
1,634.
I thought that's what I said. If I did, I missed
Oh, I'm
it.
sorry. I just heard 634.
No, 1,634.
My apologies.
And you
Emily, you've disassociated
compare
from the math.
that
Yes.
to the 7,200
physics nerds.
pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So
And this is the best point for the defense, isn't it? Emily, stop eating your breakfast when they're saying things you need to comment on. This is the best testimony for the defense. You don't need the force from a car to cause that injury. You do not need the force from a car or a collision with a car or a strike from a car to cause that injury. Those injuries can be explained from a fall backwards. Period. So there would be other injuries if they were greater where you would need more force. But we had, Dr. McLagerfeld coming in and telling us that a fall backwards alone is enough to cause those injuries. So that's where they're getting to with this, right? So the dummy just falling backwards, just the force of going from standing to falling, that's enough to cause those injuries. And for the defense, that is a great argument. Nothing else needs to be focused on. They can argue just that. These injuries can be explained in two ways. One of them doesn't involve a car, if there are two reasonable explanations. So there is room for them to argue that. They can still argue that there was no investigation, there was no good investigation. But when you take the neurosurgeon, this expert, and the coroner, it's not a reach of an argument. It is actually a very linear argument to say two things could have happened here. I mean, more than two things could have happened. But if we narrow it down to two things could have happened here. And the coroner couldn't pick which one because two things can explain it. So that is a great argument for them. And I think a easier argument for the jury to understand, because you're not trying to answer a ton of questions. It could be this, it could be this. Okay, well, if it could be both, then we don't have that threshold. Okay. So we will see as they are talking about the injuries.
I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying...
And if they're going to have a nerd off, they're going to lose the jury. They need to stop having a nerd off contest with each other and get back to, so these injuries can happen from just a fall backwards, right? Okay, let's stop having a nerd off then. Because most of the jury is going to be like, I don't care who knows what value of what equation for Newton's laws.
Acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
It's fair. Tom in the chat said it's not a nerd off without a Star Trek reference. I mean, we got to the Force. I think we arguably are Star Wars adjacent.
Number 25?
We haven't gotten to Star
That's
Trek
what
yet.
I think it is. I just want to check your report.
We also don't have any Doctor
Would you like me to actually pull up the paper?
No.
Okay.
Nope.
Just want to
Turn it over. Turn it over. Would you like me to pull up the paper? He said no, and you're still looking at shit.
That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have
He's
my
looking
report,
at
but
it.
reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not
That's not a position you want to
discuss
be caught in on
the
cross,
percentage
Alessi.
of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next question.
Can I go to my slide?
Whatever you can use to determine
To answer the question.
what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question,
What?
and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
It's
This
fair if it's in the
article
slide.
was published back in 1979, correct?
I believe that's correct.
It's
Don't start-
46 years old, therefore, if I did the math correct.
I object. I object. You are not mathing properly. Chat, I'm being hyperbolic. I know he's mathing properly. This is after I was born. So I'm being hyperbolic. We've been attacked.
Right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common
making a
injuries
fair point.
as a result
I'm
of
being
pedestrian motor
hyperbolic.
vehicle collisions
Why use a study
are
this old?
injuries to the lower extremities?
Right. Why not use a newer?
I'd have to see the study.
Why not
It
use a
wouldn't
newer
surprise
study?
me. Car technology.
And again, Alessi makes a good point. Why are you using a study when we have advanced technologies and things have changed? And if there are newer studies and the 1979 study is still the best one, it would still cite it.
Especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes.
What did you say? What did you say? Cars have autonomous braking, so you're getting fewer fatal collisions? Let's back that up. I'm real curious about this. Real curious about this. I'm real curious about this whole subject matter.
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries.
Sense.
It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the
Can we get back to
most
braking
commonly
systems?
understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities?
Hey, Jack's about a source.
I'll allow the question.
He didn't agree with
So
that.
I'd want to see the data. Again, most cars, for example, this Lexus,
Tell me.
has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
What kind of safety systems
Do
with
you
backing?
have knowledge, as you sit here today, whether the most common injury from
Alessi.
a motor vehicle accident is to the lower extremity?
Who cares what
I'd
he
have to
says
look at
about
the
that?
literature. I have the article I gave you.
So the
Ask
answer
about the
is you
backing
don't
up
know
system.
the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right.
Move off that point. Get back to the pre-collision systems.
Newton's second law analysis that we went through.
No. Stop going through the checklist. Ask about the collision systems.
Force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that.
I know. I want him to
calculation
change
on your
gears
direct
too from
examination.
Newton's laws of physics. I really do.
I don't think so. We didn't discuss a whole bunch of those things that were the sub. That wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
No, he didn't.
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no. The general concept of the drop testing and what it showed, yes.
Okay. I don't think he needed to.
So instead of that calculation, you
I don't think the
referred
jury
to a
cares.
flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M
I think
and
this is
458
a
for the
difficult
G
road on
to come up with
cross.
7,200? Was that anywhere on your slide presentation?
So the slide
this
presentation
is
showed
way
the
too picky.
458 Gs. The rest of it was not on there.
Dude,
Thank you.
Alessi, move
You're
on. This is not this. Look, you can have a math off with this dude another day.
You also indicated
not helpful.
that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
You called it like a wind fin and a bunch of other shit yesterday.
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property?
Didn't you go
No,
into
I
the...
stayed in the street. It's my understanding there were new owners.
Oh, that's fair. You didn't
Did
go
you
onto the
consider
lawn.
the scene limited to the road?
So
However, I think that's the first time the jury has heard that there are new owners at 34 Fairview. The jury has not heard that before. I don't know if they're lost with the math off on the physics, but the jury has not heard that there are new owners to 34 Fairview until this.
the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In
Well,
my opinion, I did access
the
the
street and the
entire
lawn,
scene.
right.
I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was.
Where did that number come from? Where did that number come from? 7 feet onto the grass for the point of rest. Where?
I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass
Yeah, you
and
can see
stand
it
at that exact
from the
location,
curb.
but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all
Lasers.
that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
I like
Do you
where
know the
this
height
is
of that
going.
berm?
I believe it's 4 inches.
Because if the car was parked at the berm and John O'Keefe got out of the car on the berm and the yard, then he's 4 inches up from the testing because the berm and the yard go up. So if he's on the grass, then it would make it at least 4 inches taller from where he did all the paint. Why are we fucking with the physics? Why are we having a physics contest when this is the main point of the cross? Fuck the physics. This is the point.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire.
If tires were spinning on grass, because at this point we have the cat's track dusting of snow, and the berm is 4 inches and rounded, so it would be grass. If the car is spinning on grass, then there would be marks on the grass.
Tire will be at the height of the curb. So if he's,
we're getting to lots of possibilities.
Whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street.
Right.
Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, you remember you had the ruler and you measured the height? You did all that?
Yep.
Where was it? It was you? Was it you in that slide?
It was.
Where were your feet?
On the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground.
Right, if he's standing on the grass, then what?
For the spoiler, and you took a measurement. And you said that that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do either one of those.
So the point is, it's...
But there's no reason to believe that the car would be on the berm or the grass based on everything that we've seen.
Certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you,
he's like,
in
but
your
heads
slide
move.
Yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that thin spoiler because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
The eye?
You don't have the information necessary to conclude with any certainty that Mr. O'Keefe, at the time of impact, had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me 2 questions. I absolutely considered the berm. And the second question when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Oh, boy.
Likewise.
But wait, there's more.
You didn't present any Newton's second law analysis
I don't think that's the serve.
regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out? Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So
He didn't ask you to.
do a force analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
they do.
So I lined up his anthropometry relative to the known height of the vehicle.
I
You
want the force
attempted to
analysis
line it up.
on the braking.
That's
of the
one
taillight,
method,
though.
but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Alessi, why don't we break here?
Thank you, Your Honor.
And we're breaking for lunch on Newton's laws of physics.
Please rise for the jury.
Okay.
Goodbye.
And the court is out to lunch, I think probably for about another 20 minutes. So we are at the lunch break. Will we be taking a lunch break? Yes, we will. Why? Well, we need food. We need food. But we are now at lunch on day 22 with Dr. Welcher still on the stand on cross-examination now with attorney Alessi. I think this witness will be on the stand the rest of the day. I'd be surprised if he finishes before the end of the day. But I'm pretty sure at this point, I am feeling very confident in like weather forecaster terms that this is the last witness for the Commonwealth. I think we are just about at the end of their case. The court did indicate tomorrow would be a half day to the jury. I don't know if that means it will be a half day for the lawyers as well, or if the court is going to take care of housekeeping items in the afternoon before we move into the defense case in chief and the defense witnesses. So now that we are on to cross-examination, some of the parts of cross we've gotten very, very lost in the weeds. There are things about this expert that just frustrate me. He has been admonished by the court numerous times to stop looking at his computer. At one point, she told him to just close it, and he didn't. And as Alessi's asking questions, he's still like searching through the computer on the stand to look for things. It's incredibly frustrating to watch him refuse to just sit there and answer the questions. He's like, no, I'm going to search through and find this. It is not an open book exam. It is cross-examination of expert testimony. That is, in fact, based on your memory and the work that you did. And if you need to refer to your report, there's a process for that, saying, I need to refer to my report. And then if the defense says, no, we're moving on, then you're moving on. We are now at the end of the questioning for the morning. Attorney Alessi is asking about the experiments that were done. We are talking about the spoiler or the fin from the top of the Lexus that was in some of the photos yesterday, and injury to John O'Keefe's eye, and whether those things lined up. But I think the point that Alessi made that was quite good, I just hope it doesn't get lost in all of the arguments over physics equations, was you did all of this assuming that the Lexus and John O'Keefe were at the same level. And that's my summary of it. You did all of this experimentation and measuring, assuming that the Lexus and John O'Keefe were both at the same level, street level, essentially. And that's the same for the arm hitting the taillight. But Alessi asked, okay, how high is the berm? And he said, and the berm curb, same thing. And it's a small rounded asphalt curb that just goes into lawn. There's no sidewalk or anything beyond that. And he said about 4 inches. And we started getting into, okay, but you didn't account for if John O'Keefe was standing up on the lawn. And the expert said, well, I didn't account for if the back of the SUV was up on the lawn and if the tires were spinning on the curb. Well, then, I mean, if there were tires spinning on the lawn, there would be evidence of tires spinning on the lawn, one would think. And we didn't see any evidence of that, and there's been no discussion of evidence of that. I am curious if after lunch we will get to Alessi arguing the same thing or asking the same thing in cross about, well, if John O'Keefe was standing on the yard, on the lawn, then if he's 4 inches up from the street, doesn't that change where the taillight would contact with his body? Like completely change it. And for the first time we heard this expert say, for the first time we heard anybody say, that John O'Keefe was 7 feet from the road. Exactly 7 feet. 7 feet from the road, southwest of the flagpole. And he said that he got to that from descriptions, from the video, from first responders, from where the flagpole is. And that's where he tagged that 7 feet from as the point of rest. We also saw earlier on in the questioning today, Alessi starting to get into questions about the timing of what key cycle and where this collision with John O'Keefe is supposed to have happened. And the expert was very clear and repeated himself numerous times. We do not know when John O'Keefe was struck by the car. We know he was struck by the car, but we do not know when in time that happened. So Alessi was trying to get through the questioning about Trooper Paul's report and the Commonwealth's shifting timeline and said he was going to come back to it. I think we will see him coming back around to that after lunch about which key cycle was aligned to what incident in Trooper Paul's report. But Alessi's going to have to go about that questioning a bit of a different way. And I imagine over the lunch break, that's exactly what he's going to be thinking about, is which way he wants to approach the differences between Trooper Paul's report and analysis and this witness's report and analysis. This witness said he reviewed Trooper Paul's report. He did not say he relied on it to do his own analysis. So there's going to be some questioning about, I think, the differences. But Trooper Paul's testimony is not in this case, and Trooper Paul's report is not in this case. So it's more of a narrow, a needle in a thread type of questioning that's going to happen with that. I was surprised at how much the court had to admonish this witness, and the court interrupted sua sponte, meeting on her own, to tell the witness to stop looking at his laptop. I am flabbergasted that that had to happen more than once, but the court admonished this witness in front of the jury numerous times about referring back to his report. I think the cross got very lost in the sauce on the questions of physics. I think getting into, well, you only accounted for one possibility and there are numerous possibilities, is a very good line of questioning for the defense. It is the Commonwealth's job to close the doors to all possibilities but one. And this witness has said numerous times, it could be this, it could be this, it could be that. We don't know exactly how this happened. The witness also said in his earliest testimony this morning on direct that it is his opinion that the taillight on Karen Read's vehicle would be broken from a collision with John O'Keefe so long as the vehicle was going more than 8 miles an hour. You're sitting there going, Emily, did he explain how that happened? Did he explain the amount of force that was needed to break the taillight? Did he explain why 8 miles an hour was the number, you know, where you drive by and everybody sees you? No. No, he didn't explain any of that. And maybe it'll come up again on cross. I hope it does. And he also explained that he believes the injuries to John O'Keefe are consistent with striking a Lexus identical to Karen Read's, or being struck by a Lexus identical to Karen Read's. And those are his opinions. I'm interested to see after lunch if the cross gets into why 8 miles an hour and the force needed to break the taillight. Oh, I left something out. The witness also said, because so much has happened today, the witness also said this morning, well, there were two theories about the damage to Karen Read's taillight. A glass being thrown at the taillight and hitting John O'Keefe. There were two theories about it. And Brennan actually had to work pretty hard to come back around to get this expert's opinion that the damage to Karen Read's car could be caused by John O'Keefe. Because his initial answer was, well, there's two theories on how that happened. The glass being thrown at the taillight is going to come up more, I think, in the defense case. But if there's two theories of how it can happen, are you closing the door to all other possibilities? Or is the jury going to sit there and say, okay, well, John O'Keefe could have thrown a glass at it, could have hit it with his arm. Either way, it's still the car impacting with John O'Keefe. I don't know. It depends on how many doors this witness is able to close. But he has said repeatedly, we do not know how exactly John O'Keefe was positioned when this glancing collision happened. We do not know where exactly he was positioned. We do not know what speed he was hit at. There's a lot of we do not knows on how this happened. So after lunch, what do I hope to see? I hope to see questions about the force and or velocity and or some explanation for how 8 miles an hour is where that taillight would break. Like, what is the strength of that taillight? What kind of force does it take to break it? I have questions. I hope that we will see more questions about the paint arm experiments and what happens if John O'Keefe is on the lawn. Doesn't that shift the entire thing? I hope that we see more questions about braking systems, because it came up very briefly and Alessi moved on beyond it. But this witness did offer that one of the reasons head injuries may not be the most common type of injury we see in pedestrian versus vehicle collisions is because the vehicle technology has changed and advanced braking systems and advanced pedestrian braking systems in forward collisions have gotten so good that there aren't as many catastrophic crashes. But he said that those systems are different when backing, and there was no follow-up question to it. I'm very much hoping that someone asks a follow-up question about the braking systems on the Lexus, because this is the first time anyone has addressed in either trial the fact that the Lexus had advanced braking systems. I'm going to check my notes because I want to make sure I didn't call it the wrong type of thing, because there were multiple systems that he talked about in the vehicle. Sorry, not advanced braking systems, pre-collision systems. This is why we take notes. And he started talking about the Lexus having a pre-collision system if it senses a pedestrian in front of the car. And then they moved on. I very much want to know what the Lexus is equipped with for backing. Because if the jury, I can't imagine that the jury is sitting there going, but does that exist when you reverse? Does it beep if there's something behind you? Because most cars do. And this is a newer vehicle. So what if any testimony will we hear about if there is a pre-collision system or what type of sensors they are if a pedestrian is behind the vehicle? And does that change if a pedestrian is to the side of the vehicle, as they are saying? I think those questions need to be answered, because most jurors, if they are driving modern cars, are going to think of their own experience driving. So I think it's a question that has to be answered, because some cars are going to alert you differently than others. And if the jury doesn't have an answer, they're going to fill in the gaps on their own. And it's the job, I think, of the Commonwealth to fill in those gaps and answer those questions. And that's probably why Alessi didn't follow up on the question, though I desperately wanted him to. Because if he doesn't know what the expert's going to answer, he's not going to ask this expert. He's going to ask his own expert. And that's what I want to hear more about. So does Karen Reed's car beep when there's someone behind it? Is that true if something is to the side? Does it have braking when you are backing up, or is it only a forward pre-collision system? We'll see if they address it after lunch. Law Nerds, I'm going to answer a few questions, and then I'm going to take 15 minutes to go to lunch. If court's back a little later, I might be back a little bit later because court is now at lunch. Let me go ahead and change the pinned message so it's clear. Also, if you don't have the Law Nerd app, make sure you get the Law Nerd app so you know when we are back from lunch. Let's see. We are at lunch. Court is on lunch. Let's see. What else do we need to say? Court is on lunch. Emily will be back. We got to give it around what time would it be? 12:50. Yeah, 12:55 CT. Okay. I'm going to answer a few questions, and then I am going to take a quick lunch to go grab some food because it is needed 100%, like 100%. So let's get to a few questions. Insert name here says, Law Nerd app rocks. My kiddo hears notifications and screams, Emily! I interpreted the way that scream would go. Didn't Dr. Rentschler with ARCA help Toyota with their safety features? I don't remember. But I guess we'll hear about it when Dr. Rentschler testifies, because wouldn't that be fascinating? We will see. But I don't remember. It would be good to know. Let's see. Gwen Rivers said, for over 20 years, made proposals and presentations for a medical company. I also edited slides for doctors who didn't understand uniform font and size. That orange slides with orange text wasn't a thing. I need brain bleach. The slides were painful to look at. And the fighting over the slides were painful. Just wild. WV Country Guy said, I spent 15 years in biomechanics. Dr. W should have done control trials to find minimum speed to shatter lens, then with instrumented soft arm at recorded speed and compare results to injury observed or not. I would like to have seen some tests. I mean, it seems that you could have an arm on something that spins so the arm moves out of the way like a body would move out of the way. One would think. But it seems that they didn't. I very much want to know. Like, I very much want to know. So let's see. Christopher May says, where is the foundation for the opinion about the taillight and 8 miles per hour? I have no idea, because we didn't hear a thing about it yesterday. Just a thing about it at all. Tracy said, Emily, did you know that the exact model of Karen's Lexus 570L can have air suspension that raises and lowers the vehicle by up to 2 inches? I, Emily Human, am aware of that. Emily watching this trial is not aware of that because nobody has brought it up. It has not come up in court at all. I have wondered, but it has not come up in court at all. And they have not talked about how long the Lexus would need to be still. Like, if the Lexus is still but running at the curb, would it lower? or not? Or would it raise when it starts going backwards? How much would it raise when it starts going backwards? It's not come up in trial at all. Like at all. Greg said Lexus would certainly have a reversing camera and collision alarm. It should, though we do have an interview of Karen Reed saying she was blasting her music. And there was video last trial of them driving in Karen Reed's car showing the reverse system working, and we have not seen that this trial. It has not come in at all, and I think that's because Trooper Paul did it. And here's my speculation. I am speculating. This is me speculating. They didn't want to bring Trooper Paul in. That's clear. That's not speculation. Trooper Paul and others from Massachusetts State Troopers are the ones that did all those drive tests with Karen Reed's car. We know from Burgess that when they tried to put things back into Karen Reed's car, it did not work. My speculation is that Karen Reed's car is no longer drivable, so they could not replicate those tests again. It doesn't seem that they did those with the Exemplar vehicle to show how the backing system works. And they did not bring in any of those videos that Trooper Paul took, because it opens a whole can of worms with Trooper Paul. But there were those videos. So we will have to see if they ask about the pre-collision system and whether or not, and whether it works in reverse or how it works in reverse. So let's see. Casey Cat said, big congratulations to my badass 5-foot-tall soldier girl on her new promotion, but then dropped that instead of retiring in 2 years, has gone special forces. She's going to be the death of me yet. Casey Cat, congratulations, and congratulations on the promotion to special forces. It's so funny. The military friends that I have, they're like, no, I'm retiring then. No, I just signed a new contract. It's like, what? Congratulations. And yes, the parent heart is like the excitement, and then the like parental like is so real. It's just so real. Travis sent a picture today from camp because he has on the most ridiculous pink SpongeBob shirt, which I love because, well, on Wednesdays we wear pink. So I am so excited for him. The username found gifted 5 memberships. Thank you. And to everyone who gifted memberships, thank you. Casey Cat, thank you for the gifted memberships, and congratulations again, because all the pride and stress and worry, and they all get jumbled up. They need to make like an Inside Out parents version. Like it's a whole different realm of complex emotions. Luck Nessie, thank you for the gifted memberships. I appreciate it. The wondering sub. We're going to welcome to all the new members. We are going to be finding time to do a members only soon. I will let you know in the members tab that you will see. Thank you, Lyndon. So you guys will see that in the tab. I'll also announce it on stream. I just need to look at the calendar. It's been a dynamic week, and June is a month of much wild travel. So if this is the Commonwealth's last witness, I just need the court to like give us a schedule of what we're doing. Can we just get a schedule? The law nerds need it. The law nerds deserve and need a schedule. We have things to do. It is summer. Kids are getting out of school. Travel is dynamic. There are concerts. We have to do things. But what we need to do right now is go to lunch. So let me grab my lunch music that's not going to echo real quick. Emily, are you normally more prepared? I mean, it really just depends on the day. It really just depends on the day. We had more time today, and it's still a whole thing. And then I will be back, well, pretty shortly now, about 10 minutes or 5. Woo, Emily, we're going to have to move it. We're going to have to move it. Yes, we will. Let me find that real quick, though, because I need to pull up my notes, and I didn't. Emily, you should have thought of this sooner. Yeah, I should have, but it's fine. So as I'm pulling that up, I am still looking at the chat for questions, and I will answer what I can. Do I normally have this pulled up well in advance? Obviously. Do we today? No. Barry SD said, Emily, can you explain how to join the Law Nerd Lounge in the app. I have a YouTube membership and the app, but don't understand how. Thanks. One of the mods will post it, Barry SD, and tag you on it. There's also some explanations in the app, but I think it's easier if they just post that in type, because then you have it and can just copy it and walk through it versus me trying to explain it badly mid-trial. But yes, it will get posted, because there is a way they will post how to get to the rest of it. So let's see. There we go. All right. Where is our lunch break? There's our lunch break video. Perfect. Let's get that rolling without echo, because that is exactly what's needed. And it just is easier. All right. Law nerds, I will be back as quickly as humanly possible, because I'm going to grab some food. I'm going to bring it back because I don't want to miss. Ooh, that was louder than I anticipated. I don't want to miss the afternoon. I don't. I'm so curious. Carla asked, and Carla, this is a great question. How long are we expecting to be in the defense case in chief? Like a week and a half? Yeah, a week and a half. It won't be that long, but they might shift that based on who the Commonwealth hasn't called, because there's a lot of people they haven't called. So with all of that, let us get to lunch, shall we? Law nerds, I will see you in just a minute. Don't forget to hydrate, grab some food. I will let you know in the app when we are back. If court's a little late, I'm going to take the minute to grab food and eat. I will see you soon. And then we will have plenty of time to chat when we are back. Bye. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. All right, y'all. It's time. It's time to get back to court. I grabbed some lunch. I talked to G because, well, it is officially summer around here because school is done. Where did I put the... I need to turn my fan down. And I had to turn the fan on to get the office to cool down just a little bit. So, you know. We're getting back to cross-examination now. So let us just roll to court. Let me switch over our streams. So we have Court Watch. Court just came back not that long ago. So they've only been back in session for just a brief period of time. So the Law Nerd alert has alerted the Law Nerds that we ride from the lunch break. So let us get back to court. It is time. It is time. It is time to resume with cross-examination. I'm sure Mr. Alessi had some time over lunch to think about exactly how he wanted to approach certain things and then talk to co-counsel about how they might want to approach certain things. There's a lot of a team of support there for them to work with. And that's exactly what they were doing over the lunch break. Do lawyers always eat on the lunch break? No, not always. Sometimes it's just working. And I wouldn't be surprised if that was the case here. Let's see if this witness has all his shit off the stand too. Like, did the court take away all of his
Mr.
stuff?
Alessi, whenever you're ready.
I hope so. I think they probably did. He was told to get all of his stuff off the stand. I'm just curious to see if it's all down. And it's fair to take a moment to get all your papers together.
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same. Alessi's
We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration.
We had talked about those parlances.
I now want to continue on with that discussion.
I don't.
It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis.
Oh, I see where he's going.
On any
bones are
bone.
on the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
The ski experts do it. We've watched them do it.
The force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report
bones are on the inside.
do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now,
I understand why Alessi wanted to make sure that they were on the same page with what a force analysis is, because we're getting to, okay, but how is the arm not broken if there's enough force to break the taillight? I think that is a very, very good and fair analysis and a needed question. So I understand the groundwork that needed to be laid, but it took so long.
given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
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 Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to
that's fair. The cross-examination is not
the
place
arm,
for it.
and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, Mr. and we're going to...
The microphone's literally taped right there on the podium where the papers are. And then on the other podium, and we can't see what the witness is doing, but he kept bumping into it too. Everybody with the microphones! They need to paint them like bright traffic cone orange or something.
Apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well,
okay.
what
Why?
number would you like to apply for an M
And then tell me
for
how much
the
the
hand
human head
of
weighs.
Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
No, he's asking
Okay,
for the hand.
fair enough. So the whole arm, is from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour.
It sounds like the witness
the
is
third
writing,
variable
and
I'd
then he's the
like
one
to
on the
give
microphone.
you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this.
What info do you need?
What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
It's
So
not
you want
Mary
a
Kate, it's
direct
them.
head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. Well, so let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay.
Tell me when you're ready, sir.
You
Go
can't
ahead.
just say, may I use my
So
calculator?
let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Okay. Adam in the chat said, done, pencils down. We definitely gave some time for the calculation. I'm glad the camera's gone back. I really want to see what the witness is doing with the calculation. Because the reason I'm not zooming is because we are running a test on the stand with the witness doing the calculations that he didn't do in his work. So we are going to watch. A number of you in the chat have asked, so we're back to having the math off. Yes, we are back to the mathletes mathing on the stand. It's a fair question to ask this witness. It's completely fair. I think when you get a witness whose opinion is that the damage to the car is consistent with hitting a pedestrian and the damage to the pedestrian is consistent with hitting a car, I don't know how you can say those things are consistent without doing a force calculation. If you are the biomedical engineer who's also acting as the biomechanical engineer. So, yeah, it's a fair thing to ask.
Okay, question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic application of the numbers, correct? You divide.
Correct. We're doing a little simplification in terms of the crash pulse shape, but generally, yes.
Right. So, but let's take the conservative number,
Okay,
the lower
men.
number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact?
No, we're not. No, we're not. No, we're not. We're talking about distributed loads versus concentrated loads, Mr. Alessi. Can we are talking about different types of loads. We are not. We are talking about how the load impacted. Mm-hmm. Mm-hmm. Mm-hmm.
To do your calculation? I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand
What kind of load
bones,
is being taken to the center mass, Alessi?
You know what I'm referring to, the phalangeals,
Yes.
the metacarpals, and the carpals?
Correct.
We got to
How much
phalanges.
pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're going to need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of,
The
contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Mr. Alessi, can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV, right? Well, let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testify to on direct, you don't know exactly where that point of contact is, do you?
Correct.
You don't know.
Except it's on the taillight.
You don't know where the point of contact is. He said, right, except it's on the taillight. So you do know then.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no first-hand witness that saw, under your view, that it.
He's saying it's on the taillight because it has to be
Where the arm was, correct?
to explain
There's
the
no
taillight
person
breaking
that
for him.
saw it.
Right.
That's what he's.
And
That's why he's
you
saying.
had
He's saying, I
chosen
suspect.
a point of contact. Okay, you chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. Correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay. So
It's in evidence.
You're making assumptions. You're taking what you view to be certain data, and you're coming
I mean, you
to a
asked the question.
conclusion. But that
Can we
is
see the
based
witness?
upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis.
Sir,
Let's go back to the numbers. I
do
want to
you know
stay
what those
on,
words
if we
mean?
can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm,
Yes,
I can tell you there's
load to the
data that
hands
shows
may
up to
vary.
300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350,
300.
above
What?
300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are
Under.
1,412 pounds
Under.
above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
Yes.
I'm sorry, I didn't. What was the you said?
2,180.
You said dyslexic? Or
What?
Do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
What?
Okay?
I didn't hear it.
You came up with
What?
a number for F for force of 2,188. Are you changing that number?
No.
Okay,
Absolutely
so
not.
let's go with your number of force from this vehicle of 2,188.
Alessi's not comparing apples to apples here, which is why the expert keeps saying, no, the 300 Gs comes out to 3,000 pounds of force. And you had me calculate the calculation, and that came up to 2,000 pounds of force. And the 2,000 pounds of force is under the 3,000 pounds of force. Therefore, we wouldn't expect to see a broken bone.
I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand?
Oh.
Do you disagree with that?
He kept interpreting 300. This witness keeps saying the 300 is the G's, not the pounds of force. And Alessi keeps saying 300 is the pounds of force, not the G's. And so they are not talking about the same thing together. And so if Alessi, well, I guess we'll see, because he can't answer that if we're not talking about the same thing.
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, It takes much more
He's gonna
force
say
because the
word
load's
penetration
distributed
at some
across
point,
it.
I'm gonna die.
It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
He's making his point
If you can
well.
hear my question, if it's unclear, you tell me.
No, I think this expert is making his point well vis-a-vis Alessi. Alessi is trying to pin him down, and this expert is like, I'm going to just spread my load out. But he is making his point well to the jury. The way he is not answering the question makes sense to me. And so he's saying, look, I can't answer it that way because of this and this and this. And I think he's answering it well. The more that we go round and round and round and round and round, though, the jury is going to get lost in that. Because the witness is now trying to control the questioner, not the other way around.
For not a pen,
Oh, boy.
not your bed, but for a Lexus SUV of 6,000 pounds.
Yeah, Alessi needs to rein
Is there
him
any
back in.
part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I mean, what if you got it stuck in the tailgate?
Any part of the back
Probably break a
of the
finger.
SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force?
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure.
The
So if you have
smaller
a
the
very
point of
tiny area,
contact.
you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wilk, can you pull up a slide from Mr. Wilk's, or Dr. Welcher's presentation for the back of the
I think
the
Welcher
Lexus,
makes a fair
please?
point.
The back hatch, and Your Honor, may we publish that?
Sure.
And
do you know
is
what number, though,
not
Mr.
going
Wilson?
to agree.
Mr. Wilk does, and
And
I
then
know
he'll
you
tell
need it,
us.
so he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes.
And if Alessi doesn't move on, he runs the risk of the jury thinking he's trying to have a gotcha with this
You had one
witness.
of just the
And the
rear,
witness says a
gate.
fine point versus a distributed point is different. So you cannot just say this equals that. You need one more factor.
One measuring the height.
Which is
There we go.
fair.
Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
yes,
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied?
So it's not deep enough.
You would
so
only
the load
need 300 to
more?
400 pounds of force to break the hand.
Right.
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did. I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm.
That's, I don't
is there
think, a
any
fair
part
question,
that could cause...
Alessi, because you can't, if you ask him to calculate it based on the weight of an arm, you can't then ask him, okay, but would that break a hand? We're just not going to get there. And unless he's going to get run over in this example quickly. I really wish we would just get back to talking about, right, but when you did all your blue paint experiments, you were standing flat on the same surface as the Lexus. What happens if you stand up 4 inches? This is, well, I think the witness is real happy with the way this is going. I don't think Alessi is real happy with the way this is going.
As a fracture.
So probably similarly, if you got your forearm down near that transition, I don't know if you can see the little dot. I'm talking about this area.
Yes, yes.
Right here.
Yep.
So that transition between the 2 body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
That's the point. You didn't do it for anything.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
it
Your Honor. Yes, Mr. Wolk. Yes.
All right, thank you.
Thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
Right.
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm.
Really?
So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication?
I mean, if they did no x-rays of the arm and the hand, they can say there's no obvious fractures, but they can't say there's no fractures. That's really interesting. Because there are all kinds of fractures that you couldn't necessarily tell from the outside, which gives this witness an out. I'm very curious.
Whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
The ribs.
Other than the occipital bone
and
or
the
the
head.
skull?
No, the ribs. There were fractures to the ribs, but those were from...
There's a couple bones in the skull that were fractured, but other than the skull, no.
There were rib fractures.
So,
but those were attributed to
are you
medical
aware
treatment.
that the medical examiner for the state of Massachusetts, Dr. Scordi-Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Scordi-Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No. I'm simply indicating that, for example, a hairline fracture.
Yeah, without an x-ray, there could be a small fracture to any of the very small bones in the hand that wouldn't be an obvious fracture. They were looking for obvious fractures. There weren't any obvious fractures.
Didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that?
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, that's not what he said.
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body.
That's not what he said.
And that the clinical judgment of the medical examiner should not be accepted, and there should
Alessi,
be an x-ray
that's not
of
what he
every
said at
bone
all.
before a conclusion can be drawn that there's no fracture to a bone in the body of a deceased. Is that your testimony?
No, that's
Absolutely
not what he said at all.
I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
Unless
Ask
he
me
keeps
about the
changing the
opinion of a medical
goalpost.
examiner. I'm not a
Hold
medical.
on. Only one person.
Unless
at a
he keeps
time.
changing the
Mr. Alessi,
goalpost
let
with
me
his
finish,
answers
and then you can ask
or with
the
his
question.
questions.
Sir, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare.
It's a nightmare for the court reporter, but Alessi said, so you're telling me there's no fractures, and he said no obvious fractures, but I didn't see any evidence of an x-ray of the arm, so I can't tell you that there's no fractures for certain because I didn't see an x-ray, and there can be fractures that you can't see. That's fair. Fair enough. And Alessi's like, so you're telling me the medical examiner has to take an x-ray? That's not what he said. That's not what he said at all. He said, I didn't see an x-ray, so I can't tell you that there are no fractures. There are no obvious fractures. There are no bones sticking out of the skin. Okay. Nobody said when they touched the arm, the bones moved. Okay. But there could be more. This line of questioning is not going well at all for the defense.
I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of
That was not your original question, but to answer your question, no. Except for the skull.
Welcher would have had access
Except
to the
for the
autopsy reports. Yeah, all the reports, photos, x-rays, if any were done. He should have had access to all of it, which is why he's saying I didn't see any evidence that was done. It wouldn't have needed to be done for the autopsy.
Do you
But he can't answer that.
understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scordi-Bello, in the conclusion she reached in the autopsy report that you read? Did you read the conclusions of Dr. Scordi-Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scordi-Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
I think he can ask if he's aware. I don't think he can ask what it is. He rephrased the question, but there's not a lot more down that road he can go. So we will get into it, but Alessi keeps changing the phrasing of the question, and the witness is just like, that's not what you asked. And the witness on that is completely right. So this, let's see if we can zoom past this sidebar to get back to what he is aware of that the ME did or did not consider and did or did not decide.
Thank you.
And we will see. But the point is going to get lost in the sauce.
Dr. Welcher, I would like to talk now about your paint exercise.
Oh, they have moved on from that.
You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise.
He won't call it an experiment.
What I want to
That's
do
funny.
is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue?
Is that descriptive enough? And he's like, do not call it an exercise.
Blue paint test.
Sure.
Okay, let's call it blue paint test.
Okay.
I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So your blue paint test involved painting the right rear taillight blue, correct?
Correct.
Positioning the test subject behind the taillight, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one,
Okay.
okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to.
That's exactly what he wants to
So
get to.
you discussed data that
He wants
you
to
say
show that they
shows
match. Right.
that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So let's...
That was a real strong response. I'm gonna back up to that question again. Wow.
The location and area of the lacerations on his arm.
What
That's what I
in
wanna
the
get
world? I had to back up.
So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is
yeah,
that
he didn't
correct?
say that.
No. Where'd you get that from?
Hold on. Okay. The answer is no. So let's... Did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
I want to know more about that. Can you tell me more about the backing pre-collision system? Please?
Let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour.
Could you have used other things?
If you used a crash test dummy, correct? You could have done that.
If you used the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able.
See, we should have skipped all the other stuff and gotten to this. We should have skipped everything else and have gotten to this. This is the point. This point. We might not have gotten test results that we like. And then we would have to come in here and explain why the test results are different. That's the point he's trying to get to. That's the point. We don't know how it's going to turn out. So we're not going to do it. I'm going to back up and let this man finish his answer in entirety, because that is the point. That's the point that Alessi wanted to get to. I wish we had gotten there faster.
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour.
I backed up a bit far, but I'm really curious.
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
Okay.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you used the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
Exactly. You don't have enough information to conduct that test.
My understanding is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No. There is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Let's talk about the other information you don't have.
Okay?
Let's talk about the podium.
Information as to the, from your alleged point of contact to where Mr. O'Keefe landed, you don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I want to go through the information that you don't have.
Okay, doke.
So you don't have that. You don't have the point of impact. You don't have where in
Right.
the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where the, under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled
Seems
a
that we have
distance of
moved.
87 feet. Do you recall that?
Oh,
You are
total.
mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Woke gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Woke to go
boy.
through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something
remember, and a
number and a
50.
50 number, and you came to 87? Do you remember
Forward
that
and
in your
back.
slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
multiple times now, this witness has mentioned pre-collision systems. He even mentioned backing pre-collision systems. And it has not been followed up on. I think it's because Alessi doesn't know what he's going to say, and you really don't want to ask a question you don't know what he's going to say. But it's now been alluded to multiple times. We also didn't hear any follow-up on the blue paint test and why the assumption was made that everyone was at the same level. And it seems that we're moving on to the travel of the Lexus, and maybe we'll come back to it. but we'll see.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolk, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolk, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. To the farther to the right.
Oh, I'm not the only one that has problems. No.
Okay.
You
Sir,
still
do
don't
you
have
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So if you take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
This
So-
witness thinks he's in control of this courtroom right
You,
now,
if,
and that is
am I
a
in the right
problem
column
for
relative
Alessi.
to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward, and then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. It's that. Is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe
What?
87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now,
That's not what
Can
you
you
said on
Just
direct.
hold on, to be clear.
That's
so
not what you said.
It starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
that's what I want to get to. How many feet
Huh.
did you say on direct, and did you just say now that it went 87 feet in reverse?
That's what he just
Correct.
said.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear.
Interesting.
How many feet do you believe the Lexus went in reverse?
He just
based
said 87
upon
feet.
your PowerPoint presentation? Not when
Yesterday, I thought it was 53 feet backwards. And now we're at 87 feet backwards, which is staggering.
it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward,
How many motherfucking feet in total did it go in reverse? From the point that it started reversing. How far in reverse total? So you go forward, that's forward. And then you go reverse. How far in reverse? How is that the question that doesn't make sense?
then it went in reverse.
Right. And the forward motion doesn't count as reverse. Holy shit.
How many feet do you believe the Lexus went during the trigger?
So it went a total of
That's a
80. It went
different
34
question.
feet forward. Then it came back 80 or another 50.
So it went 34 feet forward, 34 feet backwards, and then another 50 blah, blah, blah backwards. to get to 87. So literally, you take 1 step forward, 2 steps back. 30 forward, 34 forward, 34 backward, then an additional 54. 87 feet is a long way backwards.
3 feet past where it went.
Exactly.
Exactly. That's exactly what Alessi was asking. Where the fuck do you have room to back up for 84 feet? He said 87 backward total.
How many feet do you believe the Lexus went during the trigger?
Wow.
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So,
wow.
You've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury.
Wow.
Do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
It's a good question. It was not clear yesterday. I think Alessi has done a good job clearing this up. Some of the rest of this testimony.
Zoom in.
Alessi got
there you go.
owned.
No, go back to the left.
During this.
So that T in the third column for data ID represents.
During this, I think Alessi is clearing up a point that was not clear. And I wonder if it was left because 87 feet is such a long way backward. Like, where is there room? Interesting.
The trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is
very
a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
Yeah, I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay.
Wow.
Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1 represents drive?
Correct.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if, Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Alessi, so is this 30 or 31?
The court's like, I don't think that's the right exhibit.
It's I'm sorry, Your Honor, you are correct. Yeah. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue.
That's not Alessi's fault. The presentations do seem to keep changing.
Font on that.
They just need it clear for the record.
Sir.
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says shift position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Correct.
Like, for example, if you look at column H, I simply did a unit conversion.
Where'd
so
it come
it's the
from?
same number, it's just in different units. But the
No. Where did it come from? You were asked a very direct question.
black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct? As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Wolk, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage, is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35.
The court has a copy as well, so the court is also flipping through the presentation.
So
I've highlighted the slippage.
exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during
Did the load cause the
trigger
slippage or
event.
no?
Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
I'm writing a book after this.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
in reverse.
Okay. Got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
That conflates two answers.
I mean, it doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
What?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. You understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So, applying heavy
It's
acceleration
cross.
can cause the wheels to spin.
That's not what he's
Is
asking.
that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at already. So
Alessi, to me, was asking it backwards. Like, Alessi, if I was the witness, I would have had a hard time with that too, because it sounded like Alessi was asking if the wheel slipping caused the accelerator to be down and asked it backwards. I heard it the same way that the witness heard it. But yes, the jamming on the accelerator can cause the wheels to slip.
in your review of the materials that are related to January 29,
terrible
2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from
There's a lot of people.
midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at Sidebar on this.
Okay. I'm just making a note. All right. They are getting to how many people were at 34 Fairview and when. Because again, that car has wheels slipping based on the data. The accelerator is down between 30 and up to 74%. And the car is going backwards 87 feet. And nobody noticed. That's the point I think we are going to be getting to. I think these are some of the stronger points. I'm bummed that we didn't get to some of the other questions on the paint testing. I wish we had gotten to more questions on the paint testing. They will probably leave it for argument because, again, you don't want to ask a question you don't know the answer to. And this witness is not going to give a yes or no. you didn't paint test this standing up to a portion for the curb. He's not just going to say, no, we didn't. He's going to say all sorts of things. And I am sure Alessi is exhausted with this witness at this point.
May I, Your Honor?
Yes.
Thank you.
All right, back from the sidebar. Well,
Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
Where?
And your further theory is that it did.
I want them to bring in the scan of the road. And I want you to show me where the wheel turned to accommodate the curve in the road at that 87 feet of backing. Because the car didn't hit the mailbox and the car didn't leave tire marks on the grass. So where?
Did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh.
So Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, yeah, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm
Just
sorry?
one?
There was a vehicle behind it.
Just one?
Ricky's truck.
That is my understanding. In terms of on the street, is
On
your
the
question.
street, exactly. Yes. And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand what he's just testified to. Just go ahead and.
Okay, so.
Because they have the video of when Higgins arrived at Canton, so they have the timing of when Higgins and the Jeep and the snowplow arrived.
Dr. Welcher, what I want to do is to have you.
The Ford F-150 is Ricky's truck.
Using your data, you say 87.
Ricky didn't testify.
For the backup, correct?
Right.
1162.
Ryan Nagel did.
24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Miss Reed's interview statements.
Attorney Little's like, what is happening? She's just I'm trying to focus on listening, but I'm watching Attorney Little reacting. So why do you think there's no other car? I'm really glad we've gotten back to this part of the cross because we were very lost in the weeds for a while. This is much more helpful.
Information.
I should clarify. This is much more helpful to the attorney that is asking the questions. Earlier parts of cross were not helpful to the attorney asking the questions at all.
Do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Ms. Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house.
That's the truck.
And then leaving before the event.
Assume that there were vehicles, at least one vehicle, parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet.
I realize that I grew up in Southern California and I live where it like cute snows, but not like snows. So chat, correct me here. But if the road is cold enough or has enough snow on it that your tires are spinning, if you were going 24 miles an hour and hit the brakes quickly, couldn't the car keep traveling backwards? Even when you hit the brake, it feels like the road would still be slick and that the weather would 100% factor into the likelihood of a collision. Because when you try to stop, the car might still keep going like it's on a goddamn slip and slide. Sir? It seems that this weather particularly would factor in. Aren't you the accident reconstructionist? Weather doesn't play a factor here. How does the weather not play a factor here? I'm confusion.
So
how does the weather not play a factor?
That there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60-something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
okay. Yeah,
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where?
It depends on where it starts. Don't you have all the witness statements from where it started? And a scan?
Where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side. I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
Yes.
87 feet
Repeatedly.
backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Fucking fast.
Yes, I think I've driven this Lexus backwards 24 miles an hour.
So if anybody who's driven a vehicle back,
video of
have you
that?
ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when
Don't
there's
do
a
that.
storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Maybe I just, sir, it's so fast. You're not telling me that you are just like, maybe I might could. You are the scientific expert. And if you drove the Lexus backwards 24 miles an hour, I don't think you'd be like, maybe sometimes I did that when I was in high school. Those crazy kids. Sir, what?
Right. So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road, and for 34 Fairview it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots, if you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described.
That's great.
Right? The
Conditions
weather
have nothing to do with where you start.
I need to finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his.
Those are great questions. So there's multiple points that if the car started there and then went 87 feet backwards, it would end up in somebody's yard.
Question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting? You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot up into space.
Yeah. Highly, highly unlikely. But
All
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So,
I think that's the first time I've heard Alessi make a snarky comment to a witness during testimony with the let's get back to reality. Sir. No. Just no. He's very entertained by himself. You're a paid expert. Does the Lexus have like magical powers or rocket boosters that we are not aware of? I can't even. I can't even. It could just go into space. I mean, if that's really a possibility, if a Lexus is going to turn into like a fucking TARDIS, I will buy a new car. I didn't realize that was on the table.
in terms of the Lexus itself, because you,
so
under
pleased
your
with himself.
method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic.
This has just gotten
If
ridiculous.
we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167.
Good.
Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know, I'd characterize it that way. What happens is, you know, this 6,000-pound vehicle is coming and he's standing on a, you know, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Now, induce
Right.
rotation.
So it's going to contact him.
Now the weather matters?
And under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir,
I'd like to answer your question with a slide that I have.
You don't get to do that.
Addresses this exact.
Stop reading your
point.
notes.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
I mean, not my questions,
Do you
literally.
agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
on the
sometimes
image,
it doesn't
the
show.
upper left. I mean, technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking
biceps goes all the way to the elbow, so do the triceps.
Right, so I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
yes
more or
no?
less. They're angled down slightly, but more or less horizontal.
Swirling.
Okay.
Like literally.
Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the pushing across like this, and with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay, I got it.
My slide shows this quite clearly.
So you disagree. You do not agree that the injuries to Mr. O'Keefe's forearm, under your theory, would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact.
Give me a little bit more.
And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory, right, given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay.
Okay.
Isn't it the case with your theory that the tail light would have to break
to cause those injuries?
And after the break, the arm would have to maintain contact
It's a very good
with
question.
the arm as the car moves?
So that is what happens in pedestrian contacts. There is a contact duration.
That's not what he
For
asked.
example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your...
So then how does the taillight get all into the yard? If the arm's blocking it when it brakes, how does it get into the yard? How does it go out if the arm is up against it?
supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct. But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
So now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics.
That's snarky.
But you didn't do that in your report.
Nope. Always applied the laws of physics. The paint
snark.
experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this So that was an engineering experiment to correlate height, position of the taillights relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law, as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics.
I do need to point out, while we're arguing over the laws of physics and science, that the second screen does seem to be off of the witness stand. It was bothering me. So we've got to close that loop.
I would say these are the numbers, but for example, the timing in GPS, how a clock times, the concept of a second, what does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could please.
This has not been a productive line of questioning for the defense. It really has not been a productive line of questioning for the defense at all. I think it was much more productive when they were talking about the assumptions that he made. And I wish more time had been spent on, we did this to show. He said, we did this to show that the injuries can match. So you went in with a goal, and then you were the one standing there with a goal. How did you account for you not wanting that to be the outcome when you're the one standing there? I wish we had more of those questions and less of these questions. I know Alessi is trying to lay the foundation for ARCA. I don't think he needs to, because ARCA is its own thing. But I wish Alessi would spend more time on all the assumptions that he made. So you assumed this, you assumed this, you assumed they were on the ground. These are all the assumptions you made because you didn't have enough info. So you can't really give us anything more than a demonstration of what might have happened, you think, because you were looking for that to be the explanation. You saw the injuries and you went to explain the injuries. And why did you decide that the light was going to break above 8 miles an hour? We don't need to get into who knows more about physics. I don't think it's helpful.
Please, I just need to finish my question. Where in your report
it doesn't. He doesn't
use
say the word physics.
Any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A. 2A Roman numeral 1. 2A Roman numeral 2. 2A Roman numeral 3. 2A Roman numeral number 4. 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX570. Where?
Can you read the next sentence?
I'm sorry. Is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis.
So no.
But in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So
just move on.
Force was applied to my arm in the paint test.
You've
I
locked
didn't
in
do
the
an
answer,
F equals
Alessi.
MA
So no.
force analysis.
Thank
Okay,
you.
so no.
You're welcome.
Just move on.
So now
'Cause
let's-
Ark is gonna. That is laying the groundwork
Go-
for Alessi's expert. He just needs an answer. No? Okay.
Go to
Stop fighting with it.
the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry. The picture's done.
I'm sorry, we'll take that down. Thank you.
Because Arka, I need you to tell
Do
me
you agree
how
or disagree
you decided when that
given a horizontal
polycarbonate
movement
breaks.
of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is
yeah, he
this.
does.
If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So, like, is it a clipping contact?
Respect my authority!
You're on cross. It's so patronizing. What? I'm trying to help you.
Survey says.
Just the audacity. Oh my God.
Or is it not a clip?
He's asking you a question. If you can't answer it yes or no, then you say, I can't answer it yes or no. He said, you keep inserting this shit. And he says, I'm trying to help you. No, you're not. You're trying to help you. Obviously.
More likely than not that
Oh my
vertical
God.
lacerations would be an inconsistent injury pattern.
I'm trying to help you, but you got to give me more. So, like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only 2 variables you need to answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations, But again, it depends on what's being hit.
Okay.
So, for example, if I have something that bends as a result of the impact,
Oh,
it can
God.
bend up
Put the finger
and
down.
create a vertical laceration.
So you would agree, based upon what you said, that generally
The whole
horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally,
Okay.
yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want? We bring up a slide. Will that
I'd
help
love
you?
to bring up a slide.
We're going to be running.
we bring up the cha-cha slide?
thing, so we'll just bring one up, and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask
Do you
for
want me to
it,
tell you
but
the slide
think
I
we've
want?
got a
No.
slide for you.
It's cross-examination,
And-
sir. It's not the, it's not the
111
Welcher
is on the
show.
screen, sir.
It's just, it's... Oh my God. It's not the Welcher show.
Is
Welcher thinks it's the Welcher
blue
show.
paint
And
more
occasionally Alessi is
predominantly
letting
on
him.
your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car's moving is probably a little better representation.
Sir, I'm just asking you a question about this slide.
Oh no, this witness, a lot of
just-
you are asking me, and welcome to those of you that are just tuning in for the afternoon. This witness has testified as an expert a lot. No, he's trying to control the cross-examination. The power struggle that is happening here is a give and take. He is trying to control the cross-examination here. Alessi's style of cross is generally to let people talk themselves into traps. But with a witness like this, it becomes very difficult because there are moments where the witness has definitely talked himself into some answers that the defense will use to argue. But then there are times where everything just gets so off the rails, it's hard to follow for an afternoon of a pissing match between this witness and the attorney. And it's hard for those highlights and the moments where the defense has made headway to stand out to a jury. It all just kind of gets lost in the sauce. Because it is so much exhausting back and forth. And Alessi is trying to politely redirect versus no. I asked this question, you need to answer that question. You will have a chance to redirect. But Alessi is letting him talk because there's times he talks himself into answers that the defense is going to answer or argue. But it is exhausting.
Just focus on this slide here, and
it's
if you can't
hard
answer
to
it, so be
follow
it.
at
I just
times.
answered it.
Is the
Sure you did.
blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All righty. So on
It
direct, you
sorta looks
stated
like
that
it.
in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with the tail.
The precision I expect from an engineer witness who is testifying as an expert in the field of engineering is not, it sort of looks like it. That's not what I expect. Your company has been paid over, what, $350,000 for testimony that boils down to it might could.
Taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes.
My-
So isn't
I am
that
going
an
to
example
wrinkle because of your testimony,
confirmation
sir.
bias?
Stop it.
No, that's matching the contact pattern to the injuries.
Matching.
But don't you have to select among other choices this outstretching of the arm? You have to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then
Right. You were trying to match them.
And running a test to see if dynamically those matched up. So it's, you know, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight.
Stop talking about the tailpipe, sir. We have had to talk about loads. We have had to talk about direct loads. We have had to talk about distributed loads. We have heard about you spreading out your load. Sir, just leave the tailpipe out of it. However, Alessi asked about the entire back of the vehicle, and he's like, tailpipe's in the back.
In any fashion. So what I'd like to do is to go back to the question that I'm asking, which is, did you consider, as
And the
part of the
witness thinks he
scientific
is being
method,
great.
in
The
terms
witness
of
is so excited
more
for
than
himself.
one hypothesis, did you consider in your analysis any other orientation of Mr.
Right.
O'Keefe other than the one you selected for your paint test?
That question's the point.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay.
So did you consider other hypotheses? Yes, but I didn't test it. And you know why he didn't test it? He told you earlier why he didn't test it. He didn't test it because he didn't want to be sitting in court defending a different result. He said that before lunch.
Considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be,
I'm sorry, chat. I was covering his hand motion.
some slight different angles in the forearm, which is from the elbow to the hand.
My apologies. You couldn't
I did
fully
consider
see
that,
his
but all
hand.
the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternate
Sorry, chat. That was bad timing on my part.
No.
I saw a number of you in the chat asked, Emily, how would you handle this witness? Probably dumb girl. I would probably handle this witness as dumb girl. I would not try to outsmart this witness. I would just be like, can you explain it to me? Physics and all, you know, my girl brain. And let him be way smarter than me and then ask very simple, short questions. Because aggression's not going to work with this witness. And the more he talks, the more he's getting himself into trouble. And I would let him explain and explain and explain and explain and use very short questions. How did you make those assumptions? Why did you pick that one? Why is the paint blue? Like, and then we go down the road of, okay, so you assumed this, and then you assumed this, and then you assumed this, and then you assumed this. Like, how do you come up with like a clear result when there's that many assumptions? I don't understand. Because that's like a lot. So what are the things that aren't assumptions? That the taillight was broken? So we didn't assume that. Like, don't you have to hit it really hard? Aren't cars strong? But bones aren't as strong as cars. I mean, I'm not a biomedical engineer or anything. That. And just letting the little questions, just the little questions, little questions. And let the witness explain. And then you come in with the big questions. So how do you answer it if it's that many assumptions? It's a lot of assumptions. And then, oh, you're trying to match them. Do you always go in trying to match the injuries? So if the injuries were somewhere else, would you walk up to the car like this and try to match it that way? Like, so you picked this way because the injuries were there, so you were trying to match them. What would you, why did you pick facing away? Is that, you thought that would match better? I'm not good with matching games. So you picked John O'Keefe facing away from the road, but you said the body would have to stay against the car for like a while. So how's the plastic like get on the lawn? I don't understand. Alessi is going to go full like brains to brains with this guy, but little short questions as if the witness knows more than you. The thing is, you have to know more than the witness on the back end. And then you just let them explain, because they're going to explain. And this guy wants to teach. He wants to tell you everything. And he won't see it as a trap. He will see it as, oh, I get to explain it to you. You're not going to fight with me. I'm going to explain it to you. Please explain it to me. And then you have the points that you really, 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 really want to nail in for your expert. And you make sure that those get woven in every now and then. Yep. That. Is that going to work for Alessi? No, that's not going to work for Alessi. But you can't go head to head with this witness. It's not going to work. Especially for me. Going head to head with this witness would not work. Not at all. But he wants to explain. Listen to how much he talks. It's different. Like when you look at the way you see like the cross of Amber Heard with Camille, there were some let it explain, and then there was a lot of but this, but this, but this, but this, and nailing it down. This witness is not going to allow it to be nailed down. But he can explain himself into a right pickle. And I think he's done it a couple times. We'll see. But I don't get to do it anymore. I get to stay at home. Would I be annoyed? Yes. I would be annoyed.
Oh, I think I just included photographs of that damage.
I would be so annoyed. He's very annoying. But there's times he's absolutely right.
No,
but it's too many assumptions.
Did you consider any other location?
And I would want Cross to be short.
Relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence. And
you assumed that the taillight broke because of a collision with John O'Keefe. That's the first assumption you made. So everything from there starts with the assumption that there was a collision. Did you ever assume that there wasn't?
Came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the science...
These jury people. I will say, as far as all the experts go, this expert has looked at the jury the least of, I think, any expert we've seen. Because he wants to beat Alessi at cross-examination. He's not here to explain this to the jury at this moment. He's here to beat Alessi at questions.
Scientific method earlier has the scientist identify various hypotheses.
No, he's like, I'm here to tell them what happened.
The data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how
Where are those?
the rear system worked.
Where's
to
that?
see if it would autonomously brake. I confirmed it did not, so I eliminated that.
He was going to get that answer in here at some point, wasn't he? Nobody had asked him. He really wanted to talk about it. I'm glad he did. I'm glad he did. He's been wanting to get that answer in all day long.
That is a hypothesis. Autonomous. So I did a bunch of tests.
I'm backing it up because that question has been looming large for a really long time.
With the Lexus, I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis.
How?
I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
What test did you do for the autonomous braking? Did you put a crash test dummy behind the car and go flying back into it? How did you do that test?
Did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
All right, so Mr. Alessi, I think if we're going to...
I am, and I'm going to move on, Your Honor.
So...
Okay, but Mr. Alessi, hold on. We're going to do that voir dire.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could, please.
We're doing a voir dire.
Go ahead, finish your answer.
So slides 109, 110.
We're going to do another voir dire. We're going to do another voir dire.
10, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher.
We're not going to be done.
So what I want to do
is
to finish up on this point.
Oh, boy.
So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is...
You look quizzical.
Did you engage in any confirmation, and this will be my last question, did you engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
predicament.
so, okay, thank you.
All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting there while we do it exactly. So tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here until, we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone, don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. The 4th admonition: please be very careful with your social media use. We'll see you tomorrow morning.
Rise for the jury.
All right, tomorrow's a half day. The lawyers aren't done. The jury is out. It sounds like we're going to move ourselves to a voir dire. I'm curious. So I'm just going to zoom to see where we get to with this because there's stuff they need to talk about. And for those of you that are like, Emily, the dumb girl, yes, Yes. Look, man, I did a cross-examination of a defendant and he kept trying to blame everything on the co-defendant. So I just leaned into how smart the co-defendant must be. And by the end of that cross, the defendant looked at me and goes, no, he didn't do that. He's not smart enough. And I was like, but you are. Look, we get where we need to go at the end because the defendant was way too arrogant to have me talking all about, oh, the co-defendant did this and the co-defendant did that and the co-defendant did this. And at the end, he's not smart enough. Right. Isn't that the point? Because my ego's not a part of it at all. Not about me, just about getting the questions answered. Let's see. I think the witness laughed when she said stay off social media or be careful with your social media. I think it was the witness that laughed. But they're not done yet for the day. So let's see where we get to.
May be seated.
All right. Okay, Mr. Alessi, it's your voir dire.
I have a moment, Your Honor,
To switch gears, Alessi literally is like, all right, shake it off. Back to voir dire. Back to voir dire. So the jury is out. I know all of the French-speaking law nerds are like, what? It's, yes, voir dire. We're going to see what they say.
Yes.
Can I load up my slides?
Yeah, can you do that while you're sitting here answering questions? Yes.
I don't know. Or Alessi is getting to voir dire about certain things. I don't think Alessi got to finish the voir dire. The court is giving him, it seems, more time to voir dire this witness. So this is a defense requested voir dire. It's Alessi's voir dire. We'll see. But that witness is probably going to be done tomorrow. And that's going to be the end of the Commonwealth's case. And they'll probably do argument. And then we're going to be into the defense case. Whether the court will give the jury a day off on Friday is my biggest question. And then we'll get into the defense case. So the Commonwealth, to their credit, said they thought it would take them about 23 days. Tomorrow's day 23. It is a...
Okay. And we're on a very limited schedule here. Okay.
Well, now we know what the voir dire is about. It's about Trooper Paul. Oh boy. Oh boy. Voir dire about Trooper Paul. Let's go. I want to know.
Okay, Your Honor.
I want to know. They said they were going to come back to it.
Mr. Wilk, with Your Honor's permission, if we could pull up the January
And this is why he didn't get back to it.
2025 PowerPoint of Dr. Welcher in slide 36.
It's appropriate to do this outside of the presence of the jury instead of just cutting off the line of questioning. I said it was a tightrope. I said it was a tightrope with this line of questioning, and they are going to let it be explored outside the presence of the jury first, which I think is fair.
Dr. Welcher, do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to go through this
that.
quickly. That image is a drone image on the left, correct?
Oh.
I thought I had replaced that from the time I produced it, was the answer.
Correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report?
The question I want so much is the Commonwealth told you to remove slides based on witness testimony you couldn't include. Was everything they asked you to remove from Trooper Paul? Did the Commonwealth ask this witness to remove information from Trooper Paul so they could show that this witness didn't rely on information from Trooper Paul to narrow down the line of questioning? That's what I want to know. That's what I want to know.
Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint.
Looky here. Remember yesterday when I lost my mind and I'm like, why is the shoe there? The shoe was in the road. And I went on for way too long about it. I completely fucking forgot this diagram. This is Trooper Paul's diagram. Look at where everything's lined out in Trooper Paul's diagram. Ding, 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 ding. Exactly in the same place. Tell me again, sir, that you didn't rely on Trooper Paul's report, because those are in the exact same place. So you did incorporate Trooper Paul's report into your report, didn't you? Oh boy.
Yes, that's correct.
Okay, if we could take that down, I'm going to go to the next example.
That's the same.
We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With Your Honor, why do we...
Alessi, I feel for you,
I
man.
have limited... Go ahead.
So
he has limited
that
time.
Particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to...
Right. Your Honor, the witness is making it take longer. That's not on Alessi. He said I didn't use that exact diagram. You used the info from that diagram, though, didn't you?
Take the time to go to Trooper Paul's report. We have the hard copy of Trooper Paul's...
Could you turn the lights on, please?
I don't know who said in the chat, this dude wants to be in control so bad. The trick, depending on the witness, is to let them think that they are when you're on cross.
May I approach, Your Honor?
Yes.
Not all the time,
Yes.
but it has to be within your arsenal of letting them think they are in control,
May I approach you?
even when they are not.
Excuse me, Dr. Welcher. You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to?
Something showing the signature.
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Oh, he's allowed to be on the laptop this time. The court said he could use his report while they were being questioned about this outside the presence of the jury for the voir dire. The court told him he could.
Page 16.
I have that.
Yes.
Because he's being...
Now, what I want to do...
He is being questioned about very specific things outside the presence of the jury, and they need to answer they need to move through this quickly. So letting him have his laptop is fine.
Needs to go to diagram 1.
And it's going to be faster.
Republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different. None of this stuff is here.
Isn't it the case that this is
You
cropped more and
incorporated
there's
it.
a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image.
You incorporated it.
Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct.
Oh my God.
Where did you get that image from?
It's,
that's in your
is it
PowerPoint
not incorporated?
presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements
Oh my
and
God!
ID on it, but the underlying image is very similar. It's probably the same one.
It's probably the same one. It was just scraped.
Do you know of any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know
Did you go
of
fly
any
a
other...
fucking drone? Because we heard about all the permissions they needed to fly the drone and how hard it was to fly the drone and how there is an airport and blah, 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 blah. Did you fly the drone? I don't know. It's from the file. Okay. Then it's from Trooper Paul's report because he's the only one that did the drone.
source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay.
Where?
Where? Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone
he doesn't
images are from the Massachusetts State Police file, correct?
Give me 1 second.
There is nowhere else they could be from. And Alessi knows it and is mad that this dude is just like, I don't know. He might truly not remember because it's not as, well, I don't know what he knows.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second.
Did you drop? He said it came from the file.
Yes, it came in a file called cars
Exactly.
trp.jopal.
Exactly.
Okay. So
it came from a file called cars Trooper Paul.
And that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you...
Trooper Paul's report is called a cars report. The file name is cars-Trooper Paul. And you're saying it's not in the report. I'm sorry. Is it an exhibit to the report? I had to back it up so I could read the file name in again.
Yes, it came in a file called cars-trp.jopal.
Okay. So it came from... And that's the report of Trooper Paul, correct?
No. These are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Okay. Can you read the file name again that you just read?
The
Sir, were you told not to use anything from Trooper Paul's report? Because you're very much like, no, that one wasn't from Trooper Paul's report. It's from a file that says cars, Trooper Paul. But it's not in his report. His cars report. It's not in his cars report. So it's an appendix, then, to the report? Trooper Paul's file, it's in Trooper Paul's file?
folder name is...
I gotta back this up. It's not in the report. The files are in the computer.
Folder that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Okay. Can you read the file name again that you just read?
The folder name is cars-TRP period Joe Paul.
Okay.
So it's from his
Did you get the drone
file.
image from that file folder?
I did.
Okay. Thank you.
You're welcome.
Now let's go on to the May 26, 2025
So it's from Trooper Paul's
PowerPoint
file.
that you created. And I'd like to go to slides 25, 26, and 27.
I just want to know if he was told not to use anything.
Have
from
you
Trooper
discussed
Paul's
with
report,
anybody?
And then he went and used the image from Trooper Paul's file. And what he's saying is, but it's not in the report. That is speculation, but I'm so curious if that's why he's so defensive.
Today at all, the source of what is depicted up on this slide?
No.
Okay. So let's now go to where did you get the, you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I
25,
believe.
okay.
Okay. And then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27.
I saw some of you
looks like
saying
it's
he's
the same
protecting his
one. You tell
paycheck.
me.
Y'all, he's going to get paid either way.
Similar.
He's going to get paid
Similar.
either way.
Okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
Yes, he does. It's in the folder.
so?
The
Remember
folder
the
says
name of it?
cars
I don't. We'll
dot
look at it with the hard copy. Mr.
Trooper Joe Paul.
So, if I
And he
could,
said
approach, Your Honor?
Yep.
it's
So
in the
you see
folder.
what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
Is this the same report? Is it dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare, this is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's broken.
Okay,
So that's the paper.
okay. So we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to
The Google Maps
your
point is fair.
continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor.
Well, then it's going to have to resume tomorrow
You see these photos?
if it's not done.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
I know. Those are Trooper Paul's photos. Because all of us sat here last trial and went, why the fuck is there a cup in the cup holder? Was that part of evidence? Was it collected by evidence? Or was somebody bringing like a road soda with them while they were doing testing? And we had quite a lot of discussion about it.
Oh. You want me to limit it to just these 3 photos?
Yes.
Any photo that would be, this photo or any photo similar to it. But let's start with just these 3.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
Well,
I
there
have
it
photos
is.
of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle
Someone
doing
else
what's
would have to be in the
depicted
photo
here.
to take the picture, to be fair.
Someone is inside the vehicle taking the photograph.
What's
Yeah,
your
that's
best
fair.
conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor,
right.
that is...
Okay, so next topic.
Yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
If they're going to get to autopsy photos, I hope that they do not bring them up on the screen again. But I think it's clear that there are multiple things in his report that came from Trooper Paul's report. And he said he didn't rely on Trooper Paul's report, but I don't think that that means what he thinks it means. So this is going to open up a door to a whole new avenue of cross.
And I think I can do this fairly quickly.
Okay.
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the...
One before that.
Yep. I think you're... Yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
I'm not sure what
And
they're putting up.
If
All right. These are graphs.
you look to the far
I'll
right...
pause again if they're going to
I'm sorry, Mr. Wolf, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scordi-Bello's autopsy report, page 3, correct? Is that where you got that from?
It's from the report. I'll take your word for it on page 3.
So, but it is from Dr. Scordi-Bello's autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out
Okay.
and go to the multicolored image in the center,
Yeah, where did that come from?
up at the top. Yep. 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 I got it. Yep. Thank you. If you can go to the very top line, it says autopsy report performed by Irene Scordi-Bello, MD, PhD. If you could scroll back over.
Date of autopsy.
Date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay.
They went to Sidebar when they were talking about the findings of the coroner. So him relying on the coroner's report and using it in his report opens the door for him to get back into that line of questioning. Fair enough.
You are all set, Doctor?
See you tomorrow.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep it under 2 minutes?
This witness will be back tomorrow.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using...
So Paul grabbed it from the CERT report? Interesting.
It didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had...
Yes, they're leading. It's voir dire. The court's in a rush. No one's going to object. Yes, they're leading. It's a voir dire. The court's in a rush. Nobody's going to object. They want the information in. So yes, that is why he is speaking at 2x.
Absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted to be independent in my analysis.
He's trying
Regarding
to keep that door
Dr. Scordi-Bello,
closed.
did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scordi-Bello about her expertise limitations?
Sir.
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scordi-Bello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just going to...
I have
Decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scordi-Bello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here.
Right, so you considered it.
The autopsy report.
And part of those considerations were the final diagnoses.
Were the
Will you put that
findings.
back up, Mr. Woke?
Right, were the findings.
But you recall the slide that you had has the final diagnoses of Dr. Scordi-Bello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered them.
Correct.
Thank you. No
You're welcome.
questions, Your Honor. I appreciate that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But
Okay.
Mr. Alessi, how much longer are you going to be tomorrow?
Depends on your ruling, Your Honor.
Yes.
It depends on your ruling.
I'm about halfway through, Your Honor.
What?
I think it will take up tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Did you just say you're halfway through your cross?
Halfway through, Your Honor.
He did. He said we're halfway through. Hi, Fred. I know. I don't believe it either. All right, I'm gonna run that back again. He didn't think this witness would fight with him over everything.
I'm about halfway through, Your Honor.
Halfway
I think it will
through.
take up tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment
That's why they're a
that we
half
told
day
her
tomorrow.
she'd be able to make.
Yeah.
So
That's why they're a half day tomorrow.
I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day.
Oh, Dr. Welcher's getting played plenty, Your Honor. I wouldn't worry about that. I wouldn't. You told the witness they wouldn't have to. You told the juror they wouldn't have to miss their appointment. If he has to come back Friday, he has to come back Friday.
So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is the key aspect of the case.
Yes.
And we've got to be able to proceed through with the questions.
They need the time they need.
On his direct and be properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time.
Aren't you holding court on Friday? It's Wednesday, right? Like, I haven't hallucinated. It's Wednesday. You have a half day on Thursday. Why can't he just finish his testimony Friday?
To see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
My answer is that point.
Okay.
Maybe instruct the witness to answer directly.
Thank you, Dr. Welcher.
Maybe tell Dr. Welcher to just answer the question, and then we'll just get through it faster. Hi, Fred. Hi. Where are you going? To the microphone. Yes, we're going to eat the. Please don't eat the microphone. All right. Can we? I would like to wrap up the day. Can we? What are we doing? Here. Go on. Other side of the desk. Okay. Well, today was something. And now we know why there's a half day tomorrow to accommodate a juror. That's not uncommon in cases this long, that a juror would be like, I have been trying to do XYZ or whatever, and we're not going to make you miss the day. That makes sense. I get it. I get it. We're just not done yet. Also, for the court, there are a lot of reasons the court might cut off the day. It might not have to do just with the court. It might also have to do with court staff. There are a lot of reasons why the court is like, we've got to go. However, it would be my preference, if the court knows that the attorneys need another half hour to get something done, tell the jurors to come back an hour later and give the lawyers an hour to get it done. That's it. Just say, ladies and gentlemen, we're going to start tomorrow at 10. Attorneys, be here at 9. And then the jurors aren't waiting and there's no need to rush. But the court is mindful of trying to get this witness done. I don't think this witness is going to get done. He said he's halfway done. That means he's got another day of cross. And if this witness keeps answering like this, then it's going to be another day of cross. So at the end of day 22, there was a brief voir dire between Alessi and Dr. Welcher. And at the end of that, Attorney Alessi said he's about halfway done with cross, and the court reminded everyone that tomorrow is a half day and they're going to try to be done by 1:30 because there is a juror who has availability scheduling issues in the afternoon. It seems that perhaps this witness could go into Friday if there is another day of cross-examination from the defense. Am I surprised that there's another day of cross-examination? A little bit. I'm a little surprised he said he was halfway through. But the defense wants to lock in answers, which has not been easy with this witness, to lock in answers on the key points before their experts testify. Because they don't want this witness coming back on rebuttal and being like, well, no, it's this, and no, it's this, and no, it's this. They want to hammer it down so that he can't move the goalpost if he comes back in rebuttal to rebut ARCA. You need to lock those answers in. And that has not been easy with this witness. There were parts of the cross-examination that were horribly clunky and wandering. And then there were parts of the cross-examination that made the points the defense is going to want to argue. It's just going to come down to whether the points that the defense wants to argue, the jury is even going to remember before they come back to closing argument or not. Because there were times it just got very much lost in the middle. And it got lost in the middle because they were fighting over the laws of physics and what have you. Does the jury want to see the two witnesses fighting over, did you specifically call it Newton's second law of physics when you wrote it in your report? No. I think the points of the cross that were much more powerful were when they were talking about the assumptions that the expert made. You assumed this, but you didn't consider this. What about the amount of force it takes to break an arm? What about the 8 miles an hour that's going to break the taillight? How did you even decide that? How did you decide that the point of rest of John O'Keefe was 7 feet from the curb line or from the street? How did you make those decisions? And there were aspects I wanted to see the defense come back around to, and we learned, I think, during the voir dire why they didn't. There was a voir dire, which must have been what the court decided at Sidebar, about Trooper Paul's report and what this witness relied on or didn't from Trooper Paul's report. If he didn't rely on Trooper Paul's report, then there's not as many questions you can ask. But if he did rely on Trooper Paul's report, then there are more questions he can ask. And that was really the full thrust of that voir dire. What from Trooper Paul's report did you rely on? And Alessi brought up Trooper Paul's report with a drone image and then markers of where things were, pieces of plastic, the shoe, and the rest of it. And that was laid out exactly the way it was laid out in Welcher's report. And he said, no, I didn't use that image. I didn't use that drone image. I didn't use that report, but they are the same. And he said, no, I didn't use Trooper Paul's report. It's in a folder that was turned over. And the folder said cars, TPR.Joe Paul. So it's not in the report. It is in the folder. And then when Brennan got up, he said, did you know that that report is from CERT and not from Trooper Paul? Or that image is from CERT and not from Trooper Paul? And he's like, no. It seems clear to me that he took it from Trooper Paul's folder. But is that him relying on Trooper Paul's report? We're going to hear argument tomorrow morning before the jury comes in about that. Did he use Trooper Paul's report? Did he rely on that information? I think the strongest point of argument on that is that the Trooper Paul's report shows where everything was found on that image. And his report had the exact same thing. And that was shown in direct examination yesterday. This expert made some very big conclusions at the beginning of the morning today. We have not gotten all the way into what those conclusions were based on. I'm almost done. I know. I'm almost done. Getting yelled at silently by my cat. How much of Trooper Paul's report was used will be important to how much the defense can ask about it. We know the defense wants to ask a bunch about it, and we know that the Commonwealth wants to ask none about it. I have to wonder, and this is purely my speculation and wondering, I have to wonder if the experts from Aperture were cautioned not to rely on or incorporate or use Trooper Paul's report so that this wouldn't come up. I don't know if they were. I don't know if they weren't. But the witness was incredibly defensive about it not being in Trooper Paul's report and was very specific about it. That's not in his report. That's not in Trooper Paul's report. Everything else, he's like, I'm not sure if it was there. I'm not sure if it was from here. I'm not sure where it is. But he knew 100% what was not in Trooper Paul's report. So I just wonder if it's a point of contention. But there were numerous pictures from Trooper Paul's report in this expert's presentation. In that voir dire, they also asked about a bit about what he used from the coroner and what in the coroner's report was integrated into his slides. And we did see them question about that. And he said, yeah, I did look at the coroner's findings. He's like, I have waited patiently. It is the end of the day. You are going to hang out with me. You are going to hang out with me. So, at the end of the day, I still think this is the Commonwealth's last witness. I don't know if we'll be done with this witness tomorrow. But court's going to be done before lunch. They're going to take a 20-minute break and court's going to be done. So that's where we're at tomorrow. Let's answer some questions. Oh, Fred. Oh, Fred. Oh, Justin to be Fred is a big boy. He 100% is. He 100% is. He 100% is. The vet has not yelled at him yet, though. So he's all good. Where is George? George is mostly curled up on Travis's bed. But he's doing okay. George is doing okay. George is doing okay. He is. Fred just wants all the belly rubs. He wants all the belly rubs. He wants them now. I know. You can't, we're not waiting. Nope, we're doing belly rubs and questions. Oh, let's get to questions. Fred is currently pursuing a degree in chaos. I think he has a PhD in chaos. He is Mr. Mischief Managed. Mr. Mischief Managed. And he does not care at all. He was just like, I am bored with whoever else was paying attention to me, and now you will be paying attention to me. So that's where we're at with the cats in my house. Josh H. said, when did CERT fly a drone? We heard the testimony that CERT couldn't fly the drone because of the weather and then because of the proximity of the airport. I don't think we heard any testimony that CERT did fly the drone. You know what? Let's go back and look at what Brennan said. He was speaking at Mach 5. Let's go back and see what Brennan said in that first question. I'm curious too, because Brennan was speaking at warp speed and literally with all the leading questions. But let's go take a look real quick at what he said.
Mr. Brennan?
If it'd be helpful.
Because I'm curious.
Okay.
But no, CERT said they couldn't because of the weather and something else. And then CERT was never called back out again. CERT was only called out, to my memory, that first
Dr.
day.
Welcher, you were shown a
So let's see what he says.
photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
That's what he said. Did you know it came from the CERT report? I don't remember hearing that from CERT. So it's a great question.
I had no idea. I just was given it as a folder.
And the photo you were using,
I was just given it as a folder. Right. Trooper Paul's folder.
it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it?
That's fair. When you used it, it didn't have the markings from Trooper Paul's report. Okay, that's fine. It didn't have the markings from Paul's report, but it's still in the folder because it's still the photo. And the markings that he put on it and the markings that Paul put on it are the same. And in fact, I'm making promises now. I'm going to go find those two and put them side by side. Chat, I promise. Hold me to it. I'm going to find those two to put them side by side in the case brief for tomorrow. So we are going to take a look at whether those have the same markings on them. Because now I'm curious. And y'all are going to have to tune in tomorrow to see. Nope. I wanted to see the rest of what he said.
Because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case.
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again,
he said, I did not use that at all.
and that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scordi-Bello, did you ever consider...
All right. So Brennan says it came from a cert report and was then taken by Trooper Paul. My memory of the cert testimony, and I don't have the case file, my memory of the cert testimony is that they couldn't put up a drone. That's my memory. But that was one of the first days of trial. So it's been a minute. It's been a minute. Should we all donate a trip to the batting cages for Attorney Alessi to blow off some steam after this mess? I am sure he will find whatever thing he does to exercise for an hour, and then get immediately back to work. Whether it is, I don't know, running, punching, Pilates, whatever he wants to do to blow off steam. But yes, there will be, that's it. And then it will be back to work. Lucy asked EDB, what is this voir dire accomplishment for the defense? They are trying to get into the area of what was in Trooper Paul's report and Trooper Paul's findings, but that's not relevant unless this witness relied on it in some way. So they are trying to merge it all together. They are trying to merge it all together. So glad I found you. You are amazing. A road soda. I mean, I don't think it's, yes, I'm not using that. I realize road soda can probably have multiple meanings. Look, somebody grabbed a fountain pop. I'm not insinuating there was anything more in there. It just struck me so strange last trial when it's like, all of us were like, why is there a cup in there? Like if it was evidence, they would have collected it out of the car. And it's an evidence car. So why would there be a soda cup in there? Like what in the heck? You know, who's stopping by to grab swig before they go vehicle test? I'm teasing. It definitely wasn't swig. I don't even know if they're in Massachusetts. It was probably Duncan. PDGLS. I have no idea how to make that make sounds, so I'm just going to go with the letters. How is it that Dr. Welcher knew exactly where to position himself for the 2-mile-an-hour paint test, so his arm would basically roll around the corner of the SUV to get the results he wanted, but had no idea at all how to position a crash test dummy for a higher speed test? I don't know. Because when it's a crash test dummy, you can't take steps with your feet and move. And he said there are too many variables. So doing it at the higher speed, there's too many variables. Because there's too many variables. So, you know. Addicted to cold brew, thank you for the treats for Fred. I appreciate it. Orange cats are the best cats. Mine's named Frank. I mean, Travis wanted Travis wanted cats. He loves the cats. My beloved Albus passed away at 17 years old before we moved, but she was very much my cat. Also, I had her before I had children. So she was also very much like a nursery cat to the kids. So she very much like, she was not their cat. She was a second parent. She was an extended parent to the kids. So Travis wanted his own cats. And Fred and George are 100% little teenagers of chaos, just like Travis. And it is perfect. They just adore each other. But it is different. So they are all little teens in this household. It is just different. They are fun. But man, the boy cats are just hilarious. They really are. But they do miss Travis. And you know, when Travis was like in junior high, he wasn't thinking about the fact that in just a few years he was going to go to college and go do DCI for the summer and be gone because he didn't. I did. He didn't. Well, Shanda Sue said lawyer me would be held in contempt by now. There is no doubt Alessi is frustrated. It is annoying. It's not that he can't handle the cross. It is annoying. Incredibly annoying and time consuming and tedious and frustrating. And as the attorney is stuck, locked in horns in a tedious cross-examination, the only thing you can do is hope that the jury reads it as evasive and hopes that the points you are making are held on to or that they remember them for cross-examination. Because if the jury feels that the witness is being tedious for the cross-examiner, that's a win. If the jury feels that the cross-examiner is the one being tedious and the witness is just trying to answer the questions, then that is a loss for the person who is doing the cross-examination. Robin said, how many people are going to try to reverse at 24 miles an hour? I don't advise it. I know that Law and Lumber talked about trying it. I don't advise it. I don't advise it. It almost invites the jury to go do it. I don't think they're going to. But if you're a juror and you're backing out to drive to court, are you maybe looking at the speed on your speedometer going, well, that's interesting. That's 10 miles an hour or 3 or whatever. So no, it's fast. It's fast. Lily B said, who in a trial determines if a witness is hostile? The judge. And it is not based on vibes. It is purely to treat a witness as if they were called by the opposing party. Hostile witness only applies to the party calling the witness and then being allowed to treat them as if they are an opposing party witness so that you can use cross-examination style. It works different in every jurisdiction. If there are thresholds that have to be met and what thresholds have to be met, there is a process. You don't just get to call a witness and be like, they're hostile because they faced at me. You have to meet that threshold. We will see if it happens. It has not happened in this case. It doesn't happen a lot, but it can happen. So let's see. They didn't ask. Hannah said, sorry, but if this guy did all the testing and cosplaying and all of the nerdy engineer things, why was it $320,000? Why Alexis is not that much? It wasn't just this witness, though. It was this witness, everyone in his office working on it. It was also Burgess and all of Burgess's extra testing. It's also, not that I'm justifying it. I think it's a lot of money. I'm trying to explain. But it is not just this one witness. It is him, the people in his office. It is Burgess, whoever's working in Burgess's office. He said another office was involved. He didn't say how. But it's also flying to Massachusetts to download things for Burgess because Burgess redid a ton of work. It's flying to Massachusetts. It's shipping the Lexus to California. It's this witness going to Massachusetts to see Karen Reed's car. It's all of that too. So a lot goes into it. I do agree that it's a lot of money. It's not just for that one witness. So let's see. Do we think the 12 people in the box see what we're seeing with this guy? Sue asked in a super chat. Sue, it really depends. The jurors sitting there, and there are still 18 to my knowledge sitting there. 12 of them will deliberate. The jurors sitting there may find the witness evasive. They may find the defense is pushing too hard. There's times I read Alessi is pushing too hard, and it's like, just move on. And so if the jury is there, they're going to feel for the witness and be annoyed. It really depends overall on how each individual juror is feeling about a witness. There were things this witness said that made perfect sense. And there were answers when I was like, well, that answer makes perfect sense. So if you're going to keep pushing on that area of questioning, you're going to lose that area of questioning. It's going to depend on each juror and if they like the witness or not, if they understood and liked how he testified or not, if it was clear or not. I don't know if it'll weird the jury out that he was dressed as John O'Keefe. They might be like, oh, I guess that's what witnesses do. Because they might not know. But the jurors do not have as much information coming into this case as we do. They don't. They haven't seen the first trial. They haven't seen the pretrial motions. They don't have as much information. So they might read it completely differently. And that is why you bring in jurors who do not have as much information about a case, because they are not using things outside of what's being presented in court to determine this case. And they shouldn't. And it was much easier the first trial. It's harder this trial to put aside what is not known. And there is a lot that was in the first trial that this jury does not know, just does not know. So they've been presented a more organized case from the prosecution. I still think there are really big questions on how this accident happened. Really big questions. But we're not at the end of this witness yet. At all. We're not at the end of this witness. But the jury hasn't watched the pretrial arguments. They haven't seen the voir dires. They haven't seen all of that. So it's fair. Jen said, I think I've had a constant goat scream going nonstop since he first sat down yesterday. He's worse than a 2-year-old. He had moments where he was a difficult witness. There were times when he was absolutely right and pushing back on questions. And there were times where it was just a lot. So yep. Mikaduff said, is it in the realm of possibility that the Lexus grew teeth and bit him in the arm? The defense did not ask that, but if it's possible that it shot off into space, anything is possible. Anything is possible. Motion Dad code rainbow for make it all fucking stop. We had a day today, for sure, but jurors don't always read cross. Well, they don't always read cross the same way, especially depending on if they like the witness or not. So it's going to be interesting. But the things that I think the witness testified well and clearly about were Karen Reed's vehicle vis-a-vis John O'Keefe's vehicle. I'm interested to see the defense's rebuttal on that. Do I think that ultimately matters for me? Not necessarily. Do I think it can matter to the jury? Yes, 100%. I think it can matter to them. And when they've got an expert saying, yeah, this is how it could have happened, it's going to be up to them to say, well, if it could have happened this way and it could have happened this way and it could have happened this way, do we know how it happened? And that's where we're going to start getting into count 2 and arguments over count 2 as we go. And there's going to be a lot of arguments over count 2. So let's see. There are quite a lot of just you guys sharing things, and I'm trying to get to the answering questions, and I appreciate it. Daniel said, can they bring in NASA to rebut? Wouldn't that be fun if we just went on a side quest about whether a car can actually rocket into space of its own volition from Canton, Massachusetts? I want to know too. But no, they're not going to do that. This testimony had a lot of moments. Sue, also, I see that picture of Fred. That is actually Fred trying to take my camera down. That is Fred. Sue has used you. Sue has used you as their handle. Look, it is you trying to turn off the camera. I think that was a few trials ago that I posted that on Instagram. Didn't we? Caught red-handed. Caught white-pawed. Caught with the paws. All of the paws. So thank you, Sue. That was the nonsense that George was up to. Sue, thank you for the super chats. Piney Woods Law and Crime, thank you for the gifted memberships. That's what I meant to both. Let's see. Hannah, it's fair. It's fair. Lynette said, how's far to back up in the snow? The 87 feet is wild to me. Getting to 87 feet is wild for me. Absolutely wild. Absolutely wild. Let's see. I think we have Fred's brothers, Maverick and Goose. I think that's probably true. Ginger cat energy. Yes, it is. It is 100% ginger cat energy. I keep hearing people say only 1 hour for close, but have we seen anything official? I haven't seen anything official. I haven't seen anything official at all. It doesn't mean somebody hasn't said anything outside of court, but I haven't seen it. So let's see. Grace asked Emily, do we know for certain that they didn't see the trial or hear anything before? They were voir dired about it. There's always a possibility that people lie. I have found that when people are on jury duty, they take it quite seriously. Of course, there is always a possibility that people are not truthful, but they were voir dired about it pretty extensively. So we will see. But a 1 hour closing, we're in week 6 of trial. A 1 hour closing is short. It was short last time. It's short. And I think they should fight for a longer closing. I think it's needed. So we will see. So let's see. The Tracy said finally out of the hospital following surgery. Hi, everyone. Missed you guys. Tracy, I'm so glad. I hope all is going well. Richard Tomcat 007 Meadows said, I can't believe 87 feet by GPS, wheels spinning, I think. Richard, they did the mathematical calculations yesterday. They talked about wheel slippage, and then they talked about the accelerometer, and then calculating the distance. So I don't know. And the Commonwealth, I would think if it had a possibility to be less distance, I think the Commonwealth would have asked about that. The longer distance is wild to me. So, and with that, I'm going to do 2 more questions and then we're going to scoot because there are things Dr. B and I need to do before court tomorrow because it is that time of year. Let's see. We got a lot of questions today about hostile witness, but I think we answered it well. I should timestamp that every time I answer it. Alessi's tethered methodology said it's not a living document, dude. That's hilarious. And yeah, he was like, oh, I'm editing the report right now on the stand. I was like, oh my God. What do you mean? I knew that he was talking about the redactions for the court, but still, man. It's just, it was, this case, retrials are supposed to be boring. Retrials are supposed to be like, yeah, I saw that. Yeah, I saw that. Yeah, I saw that. They're not supposed to have like this much new shit. How can there be so many surprises in a retrial? Lisa G, I don't know. New prosecutor, new strategy, new experts, new defense attorneys. And that's part of why the defense, when things have happened that shouldn't happen in court, it's why the defense is not asking for a mistrial. In a lot of cases, you will see the defense say over and over again, this happened, we're asking for a mistrial. This happened, we're asking for a mistrial. You're not going to see it in this case. The defense does not want a mistrial. And they're not at the threshold where the court would just dismiss the case outright. So they're not going to ask for a mistrial. They've been asking for other remedies. They want the jury to see all this stuff happen. It's not going to happen again, or at least I'd be surprised if it did, that Trooper Buchanan is going to open and be like, oh, this is the shoe from 34 Fairview. No, it's not. You're not going to have those moments in court that stand out in jurors' minds in the same way again. I'm surprised there were that many this time. I really am. Calusa78 said, eating wild grain lemon biscuits. Thanks for the rec. Aren't they good? They're so good. I just ordered some more because this trial, we have been eating quite a lot of things. Innocent until proven guilty. Why is that so hard? Asked Emily. I know a lot of us feel like Judge Cannone is extremely biased. I see that across chats and comments daily. But legally speaking, in your opinion, has she done anything actually reversible? There are decisions I don't agree with. I think one of the closest decisions that might be an issue is the decision about the police procedural expert. But the decisions so far that Cannone has made that went up for review, the court did not find to be in error. There is a lot that falls within judicial discretion. There is a lot that falls within judicial discretion. There are rulings that I don't agree with just about every judge that we're going to see. Why? Because they're the judge, not me. And they know more than I do, which is fine. But the police procedure expert, is going to be, if there is a conviction and appeal, I think that is going to be a big issue, or can be a big issue. I was very surprised by the about face on the medical testimony. If we see a limitation of medical testimony from the ARCA Biomechanical Engineer, that could cause problems as well. But the defense is not playing for appeal. The defense wants to walk away from this trial with verdicts of not guilty. They don't want to go through an appeal at all. They've done a very good job of preserving things for appeal. And I think at times they've thrown Brennan off with the amount of objections. His questions get very leading when he gets frustrated, and they have not let him at all. And so it has been quite a different trial, and the evidence has come in very different. So that's where I see it. So with all of that, it is time to wrap for today. I will see you tomorrow. We have a half day tomorrow. Well, or at least till 1:30. So we'll be done at around lunchtime. It'll be great to see you tomorrow. The court said last week that there was court every day and a half day on Thursday. Well, Tuesday through Friday and a half day Thursday. So I'm pretty sure we have court Friday. And we'll see. We'll just have to see where we get tomorrow. So I will be back here at 8:15-ish Central Standard Time. Law Nerds, wherever that is, where you are in the globe, we will be back about an hour earlier than we were today because court was about an hour late today, and I'm sure the jury is just ready to be done. Like done. But we're not done. We've still got, maybe a day and a half with this witness, and then we should be into the defense case in chief. So, day 22, and we're still not done with the accident reconstructionist. Law Nerds, I will see you in the chat tomorrow. Thanks for being here. Thanks for being a law nerd. Take care of yourself. Thank you, Mods and Team Baker. Day 23. We'll see you tomorrow. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court. And of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.